November 9th. This session, I will be chairing. Our stalwart chair, Stephen Stein, he had surgery last week, and his surgery was a bit more complicated than anticipated. Steve is recovering. He's fine, but will not be able to join us tonight. And we wish him well and hope for a fast and speedy recovery. I can tell you from my point of view, we need him as a chair because this is a lot of effort to get ready for these meetings. And I really appreciate the job Steve has been doing, and I wish him the best. I also want to point out that Steve's condition has been going on for a bit now. And at the start of last month's meeting, I started with an expression of gratitude to Steve and explaining why he was not here last month. Apparently that little bit of the meeting happened prior to the start of the Zoom session. And I think some folks in the public were concerned about the unannounced nature of me chairing last month's meeting. So I just want to be clear that Steve is fine. We wish him well. We hope for his quick recovery. And like last month, I'll be acting as our interim chair. Unless members of the board have any thing to mention before we start, I think we can hop right into our public hearings. Board, do we have any comments or questions or issues before we get started? All right, well, welcome all the board members. Welcome to the public. We're going to start with our first public hearing. This is the continuation of public hearing for 549 Washington Street. Site plan application from PBF Hudson LLC for a mixed-use redevelopment project, including a 40-room hotel, retail, office, and gallery spaces. The site is in the GCT zoning district. Do we have any updates from the applicant?
Hi there, this is Sean Rowland. Thank you, Larry, and members of the board for having us. I have just a quick verbal update, but generally I think our application stands pretty complete, and we look forward to moving along with the process after seeker from the previous meeting. So the update I did want to share was that based on the feedback from the board regarding sound attenuation or mitigation, we did reach out to a consultant just to understand what a proposal and what it would look like to develop a plan in line with what was discussed at the last meeting. And we are prepared to retain them. And I can just share a little bit about what the proposal is. It's from Acoustical Distinctions, which is a firm based in Stamford, Connecticut. They were recommended to us by our civil engineer, Brandy Nielsen from Ty & Bond. And the proposal that they put together is really in consideration of everything we discussed at the last meeting. So helping us to understand the kind of proper parameters for maintaining a sound level that would keep us in compliance of the Hudson regulations for noise. And then also to make recommendations in regards to any sort of attenuation measures we could undertake on the site and in the landscape design. So meaning different plantings or fencing or kind of any sort of measures in that realm. So we have that. We're very comfortable retaining them and bringing them on to do that study for us should the board choose to make that a condition of our application and approval.
So just so I understand, if we were not to make that a condition, you would not do that?
Well, we reached out to them because of the feedback and conversations that we had at the last meeting. So yeah, I think we want to satisfy members of the board and members of the public as to their concerns. So we're happy and ready to engage in that with with acoustical distinctions. Yeah.
Or do we have any comments?
Well, I just wanted to comment that I don't know that Sean really answered your question, Larry, but that's okay. So I guess to the board, my question would be if we were going to make the approval of the sound, I'm going to call it acoustical design, for lack of a better term. If we were going to make us having an approval of the acoustical design as part of the conditions, is that possible then for us to do that? In other words, we can approve if we're going to, if the board decides to approve the application pending, could a condition be that it's pending approval of the acoustical design?
Laura, who would you want
Laura.
to approve that?
Pardon?
I mean, who would we want to approve that? I think is a great
Us.
question.
Yeah, Laura, if I may chime in, something that people often do in these situations is designate a consultant. For example, for this board, it could be their retained engineer to review whatever plan the applicant puts forward. So that would be a condition of the approval. That way they can move forward. They don't need to come back to the planning board itself. And we are assured that it is in good hands with our consultant.
Well, we would need an acoustical consultant. You know, I don't think that that's very specific. So we don't have one.
Aaron, are you on the meeting, Aaron? Where I don't see Aaron.
I saw his name, but I don't know that Aaron's an acoustical, engineer.
I don't.
But he was here. I'm pretty sure I saw his name.
Yeah, no, he's here. I don't know if you can hear us.
If I could chime in, I'm also happy to share the proposal, and the measures in it I think are pretty, I mean, I'm not an engineer, obviously, perhaps none of us
Can you
on
guys
the
hear me?
call, but it all seems pretty,
Aaron's
you know,
on.
like, oh, okay. But it seems like work that would fall in the purview of, you know, whoever the board sees fit to review it, but it's not particularly complex. And, you know, once again, the kind of other safeguard kind of thing we have in place is that basically everything that we would do would ensure that we're in compliance of the noise ordinance that exists. So it's, you know, that's sort of like the safeguard, is that whatever gets designed will achieve. The point is that, you know, it achieves the code that's already set forth by the city. So that was my only other thought.
Well, I just guess I'm a bit confused because if there's a condition, again, right now we don't have an acoustical engineer on our end, Patrick, and therefore we will not ever know what that is. I mean, there were some pretty severe comments from the public about the sound, and this is, you know, it's very tricky in Hudson because of all the echoing and the way sound travels here. The other thing that we talked about last meeting was also in the idea of putting some end times on when, you know, live sound needs to cease. And we skip subjects, and we never really, you know, discussed that in depth. The idea of, instead, I don't know what time you can have live music out in Hudson, but let's just say it's 11 live music, loud sound. I don't mean live band, but amplified sound in Hudson. Let's just say that it's supposed to end at 11. Instead, it ends at 10 or 9 or something like that. This is a neighborhood. I just want my board members and the public to realize that this is more than anything, a real neighborhood.
Residential,
Pardon?
residential mostly.
Yes, residential neighborhood, yeah.
And I think we have Aaron with us, and I think that Laura, you've succinctly expressed the concerns from our last meeting. Aaron, were you able to hear Sean's description of his work with the consultants, and can you imagine how a mechanism might work that could involve an external review of those mitigation measures?
Yeah, certainly. Can you hear me, members of the board?
Yes.
Okay, excellent. Yeah, so I think, Larry, what you and I talked about earlier this afternoon in anticipation of the meeting was perhaps relying on your noise ordinance for this proposal. Your noise ordinance limits there needs to be an objective way to review the project. So echoing and things of that nature are harder to nail down. However, your ordinance defines essentially nuisance sound and defines the more objective way of measuring it, which is using decibels at the property line. And so currently your code limits the amount of noise from a commercial establishment between 10 p.m. and 7 a.m. That would be the objective measurement of this. I would say that if during the operation, as the applicant has suggested, if during the operations there becomes a problem with sound, they would, essentially not operate outdoors until they remedy it. But as far as what this acoustic, there needs to be a goal for the acoustical engineer. What is it they need to achieve? Okay, and generally that would be a sound level at a property line, which again they can achieve simply by turning the volume down.
Right. I think, the difficulty is between, you go into restaurants and they have acoustical panels on the ceiling and sound baffling and soft fabrics added to banquettes, all of which serve to reduce the ambient noise in the restaurant. And there probably isn't someone with a sound meter measuring that. It's a much more subjective experience of the thing, but the result is that the atmosphere and the environment is made more pleasing. And I think between the kind of systems that have no measurability and the hard measurability of decibels at the property line, I'd like to see if we can't come up with some mechanism that allows us to ensure that there is appropriate acoustical mitigation measures put in place by the applicant that may not necessarily be tied to a specific metric. And I don't know how we might do that. I hear Aaron's reservations about if you establish it as a condition in the project to be evaluated by someone external, they're going to want a number to check to see whether they can reach that number, and then that becomes the number in the code because we can't exceed that, and then we're winding up with nothing again because we already have the code. So Patrick, I wonder if there's a way that you can imagine that we essentially require the applicant to hire the acoustical consultant of their choosing to develop mitigation measures and have those things externally reviewed, even if we cannot actually apply a data metric to the review. And how do we do that without it being arbitrary and capricious? I don't really know. I think it's a lot of that comes down to how we, if indeed we have a condition, how we word that.
Well, I think you and Aaron kind of got to the crux of it, which is the a consultant would have to review it based on some sort of standard. And it seems to me like the most obvious way to go about it would be for the applicant to have to demonstrate that there would be compliance with the NORS ordinance via this plan that it's coming up with. And we would have a consultant review that in order to state whether or not this seems like a feasible plan that actually will ensure that those impacts are mitigated.
Yeah, and Mr. Chairman, if I may, I'm Brandy Nelson. I'm the civil engineer working with Pocketbook Factory. And we actually recommended Mr. Khan at Acoustical Distinctions, having worked with him on a number of other outdoor venues that were going to have music. His credentials and qualifications are very good, very strong. And you know what he will do, and in our conversation with him, he's digesting the city's noise ordinance, but he's working backwards from that noise ordinance. So, you know, I think Sean has already mentioned that issues of hours of operation, you know, those are clearly defined. And if those need to be part of a condition, I think that that's an easy thing, you know, similar to what Patrick said, rely on the ordinance. But he'll be working backwards to develop a performance specification for compliance. And I think that would be available to be reviewed by Aaron for consistency with the noise ordinance. But, you know, we're relying on his specific expertise with sound generation and the mitigation measures that need to be in place. And some of that is equipment specification. And some of it, as Sean said, might be outdoor treatments. But he is, you know, acutely aware of the noise ordinance and working within the guidelines of that ordinance.
I guess I still don't know where we are. I mean, I just want to repeat, remind everybody that two times, I believe, there were events at the Pocketbook Factory that put out sound that was deafening to the neighbors. And that was before, you know, we approved this application. So I just want to make sure that, I mean, in other words, if the acoustical designer or engineer does this you know, comes up with a plan, and we've already given approval to the Pocketbook Factory, we really don't have a way to you know, to approve whatever the design is. We won't know what the specifics are. In other words, if it's, I'm going to make this up, if we put up, I mean, this is not going to happen, 20 trees, then that will cut the levels to X amount. We won't even know that stuff. We're just approving something that we don't really know. And I do want to, again, and thank you, Brandy, for that. I do want to consider us to consider, you know, some time limitations on when amplified sound can stop outside. That actually would make me feel very good.
Yeah, Laura, I completely hear that. And I think that, you know, I sort of like Brandy's notion of establishing performance criteria that are in the code and having the acoustical designer work towards the meeting of that thing. I think a lot of it is going to depend on how Patrick guides us through the language of a resolution, but we're not really there yet. I think that, you know, why don't we, if there's not other questions from the board or other contributions from the applicant, why don't we open it up to public commentary? And then after we've taken in the public commentary, we can look at the specifics of a possible resolution and what language might actually be able to get us to the point where we as a board are comfortable with the stipulations enough that we can move forward and still have a level, you know, the applicant gets to know that they have approval and we get to know that we have a level of control. I don't know that we're going to get there, but I think that we're all in a public hearing. And if the board doesn't have additional comments or questions for Roland before Sean, before we open it up to the public, I think that we should do that.
Okay, I agree. Good.
Board, do we have any other questions for Sean and the design team before we open it up to the public hearing? Okay. Are there members of the public who wish to speak to the application before the board right now? I don't.
Chair, as a formality, we should have a motion to open. the
Oh,
public hearing.
thank you. Was that you, Patrick, that told me that?
Yeah.
Yes.
Okay, thank you, Patrick. May I have a motion to open the public hearing?
I move.
That was Laura. Jean, you seconded? Great. Okay, are there any members of the public who wish to speak? I don't see any little hands on my screens. Yeah, curious. Okay, we don't seem to have anyone who wishes to weigh in. I would imagine that after perhaps months of public input, we have heard from folks who need to speak. Board members, before I turn it over to Patrick, do we have additional thoughts or comments?
I have a thought or comment, or maybe it's a question to, maybe this is a Craig Haig question. Like, what's the enforcement mechanism? Is it literally someone there with a sound meter and demonstrating that they're violating X, Y, or Z condition or city code, and it's reported to Craig, and then Craig comes out and does what? I guess I'm thinking about this in the sense of Laura's point's an excellent one, in that we're going to be moving ahead and potentially approving something that we have no real control over. But I think it makes sense for us to understand that whatever punitive, if that's the right word, whatever steps the city takes to make sure that the code is met, that we and the applicant understand what those measures are.
Yeah, and it's not just, I mean, that's a great question, because, the noise issue is not apt to happen at 4 p.m. on a Thursday. It's going to happen at 10:45 p.m. on a Friday, when the only parties that will be reachable by the general public will be the police. And
That is what happens, I believe.
yeah,
Just
you need a
to-
noise complaint, right?
I believe, and I think they come out with a sound meter. I believe that I mean, probably Andy knows this better than any of us, but I think they come out with a sound meter to the person's, to the person that's lodged a complaint. And they do a sound test there, but I might be wrong about that.
Yeah, I mean, just briefly, what I would say is a couple of things. I mean, one thing is the city of Hudson does have, unlike a lot of jurisdictions, it does have a noise ordinance, which is a good thing. So if we're looking at a situation where at 11:15, there's all this loud music taking place, whether that's a condition that the planning board puts on, or it's in the code, which it is, that's going to provide a basis in and of itself that there is an activity right now that is happening that is outside the letter of the Hudson code. That's number one. Number two, looking at it from the reverse, I mean, if there was some sort of low level noise that, was out there, during the day, those types of noises are also picked up within your code, and there's probably not going to be a complaint because they're going to meet them. So I understand what you're saying, Laura, and you're definitely doing your job as a planning board member to say, okay, we have this use. It isn't a GCT zone. It is a permitted use, but we have to recognize that there are people nearby. What does our code say about it? What sort of assurance are we going to get from the applicant's expert that they're going to meet those code provisions? And specifically within that, are there mitigating measures that they're going to put in place, that they can put in place to address those things? And those attenuating measures would be something that your engineer could look at and could say, yes, number one, they're meeting the code. It's a really good backstop. I mean, unlike some codes, you look at those provisions, they're pretty specific. Any noise after a certain time is deemed unreasonable. You don't need a meter. You're not supposed to have it. So you have that backstop. Then on top of it, going to the points that Larry and Clark have made, okay, notwithstanding that hard backstop, we as a planning board want to have the sound acoustical expert provide information about attenuation, so that unlike the meet and greet that occurred that we've talked about, where it was simply people in a vacant lot using a single amplified speaker to kind of see the project. Clearly it was loud, but that is not, the site doesn't look the way it's going to look. The material, the amplification that's going to be used isn't going to be the same. And what you would have as a board and what your engineer would look at would be a specific plan, as Brandy talked about, with the equipment and with any sort of outdoor attenuation, so that you basically have both of those two things. And that then goes in the file. And I apologize, this is so long, but it goes in the file. And then that's there so that, wait a minute, there's a condition that they're supposed to have live music till this point. There's also a code provision that says the same thing. They're outside of it. They're in violation. They're charged. I mean, it's like any sort of enforcement. Even if you put, 3 p.m. is the sound barrier. What happens if somebody does it at 5? It's the same thing. But that's why you have a code, so that everybody, A, is treated fairly, but also that there's an objective standard for the code enforcement officer and the police.
Thank you, Eddie. I just want to also point out that in the past where we've had, this as something to deal with, we were able to see the report from the sound engineer before we approved the application. And that's, Andy, I think that this is where this is a little strange. I also want to point out that the, Sean and everybody at the Pocketbook Factory has really emphasized how much they want to involve and be the community, the residents that live there in the community, to be a part of that, to have them be a part of this. And I would think that being sure that the sound ended at a decent hour for people that get up in the morning and go to work every day, and also would like to enjoy their weekends too. I would think that would be part of, I would think that they would make special considerations for those very people that all through this application process, they have talked about, which are the residents that live in that community.
Yeah, I think why don't we get into the specifics of the language? That might really help us clarify whether we're able to get to a point of agreement amongst ourselves about how we might proceed here. Patrick, you have a draft resolution. Do you want to share screen and allow us to review that together?
I will do so right now.
I would ask the members of the public, those who are not on the board, to allow us to deliberate. Shaheem, if you could mute everyone who's not one of us, that would be wonderful.
Gary, do we need to close the public hearing, or can we just do this without closing the public hearing?
Oh, yeah,
You
we should
should-
close.
Hmm?
Patrick,
I
should we
was gonna
close the
say,
public
we
hearing?
could have this discussion before or after. But if we would like to just make it clear that this is time for just the planning board to speak amongst themselves, then we can close the public hearing.
Yeah, let's do that. Board, well, I can't say that. Board, do I have a motion to close the public hearing?
So moved.
Thank you, John.
I'll second.
All in favor?
Aye.
Aye. All opposed?
Aye,
Thank you.
Nay.
all.
whichever.
Patrick, you get that?
Yes. Our office had been asked to draft a potential resolution to grant site plan approval for the Pocketbook Factory. I believe it's being shared right now. Would you like to focus on the conditions, or do you want to go through each paragraph?
Each paragraph.
Yeah, I think we need a
Right.
quick review of the terms,
Sure.
Patrick. That'll really help.
Sure. So the first paragraph is summarizing the situation. The applicant, PBF Hudson LLC, has applied for site plan approval to convert an existing vacant factory/warehouse into a mixed-use development, including a 40-room hotel with spa, lounge, and cafe, garden room, restaurant and bar, retail office, and gallery space with a publicly accessible interior courtyard, the project, on property located at 549 Washington Street, identified as tax parcel number 110.45-3-74.100. The property in the city of Hudson in the general commercial transitional GCT zoning district. The project is depicted on a specific site plan. I will move past reciting all of the pages of the site plan. It is what's been reviewed at length before this board.
Therefore,
Pursuant to sections 325.16a and 325.35 of the zoning law and determination of your code enforcement officer, the project is permitted subject to site plan approval in that district. Earlier, June 9th, 2021, the planning board referred the application materials to the County Department of Planning and Development for their review. Under 239M of the General Municipal Law, the county responded
Patrick,
on
can
July
I
20th.
stop you here? Is that a copy paste error? Do you mean to say Dutchess County?
That is a copy paste error. So that is clearly the Columbia County Department of Planning and Development. They responded on July 20th, 2021, that this project was a matter of local concern. On October 14th, your board determined that the project would not have a significant adverse environmental impact under seeker, and that ended the environmental review. The public hearing was first opened on June 8th. This is assuming it closes this evening permanently. It would have closed November 9th. During that time, all of those who wish to speak were heard. And finally, we note that all of these meetings were held in accordance with Executive Order 202.1 and the subsequent extensions, which allow these open meetings to happen online. I will also add that the laws of, I believe it's chapter 417 of the laws of 2021 allow this as well. And that was the provision enacted by the new governor. So based on that, if the planning board wanted to make a decision, we've drafted language saying that now therefore be it resolved that the planning board hereby grants site plan approval to the project as shown on the site plan set recited above, and authorizes the chairperson or his authorized designee to sign the plat or the site plan set after compliance with the following conditions. 1, payment of all fees in escrow. This is a fairly standard condition. 2, approval by the planning board attorney of a declaration of easement granting public access to open space on the property as indicated on the site plan set for purposes of passive recreation during daylight hours, along with an undertaking from the applicant's attorney to record the declaration as soon as the site plan set is signed. Now, would you like to discuss this condition by itself, or would you like to go through the rest of the conditions and then come back to number 2?
I think that since there might be issues regarding all of the subsequent ones, maybe we take them one at a time.
Fair enough. So the purpose of this condition is to memorialize and make it efficient for the city to enforce the fact that the applicant is offering this public space on the property. I believe the applicant may have comments on the proposed language here. If you would like to allow the applicant's attorney to participate, that is up to you.
Patrick, can you summarize the attorney's concerns so we keep our discussion tight?
Sure. Andy, I believe your concerns were that you would rather have language along the lines of the following. The applicant shall maintain the open space area at the rear of the building for public use and passive recreation during daylight hours, except in those limited instances where the open space area is utilized for a private event. The difference between that language and the condition here is that we have proposed that they have a declaration of easement that would then be recorded with the county. That would be a binding document that would presumably grant the city a explicit enforcement right to make sure that this public space is indeed kept open. Whereas the applicant's language, I believe, makes it a lot more difficult for the city to enforce that provision.
Is there any possible way to do both? Because the way it's written is good, and I think that we want to be able to have it enforced. On the other hand, I mean, I don't, nobody knows how many times it's going to be a private event, but you know, is there any way they could also have a private event?
Certainly, the language of the declaration of easement could say that this space is only made available in particular circumstances at particular times. And if the board, and if we wanted to allow that space to be closed off to the public during certain events, I think that is a reasonable accommodation.
But then we lose that, we lose the, you had said that this gives us, the way it's written, it gives us what? It gives us the
It
possibility.
makes it easier to enforce.
So how do we make it easier to enforce, like you had described, and still give them the opportunity to, hey, Sean or anybody, is there no area that can be open to the public, even if you have, isn't there some place that could be open to the public, even if you have an event?
Yeah, this is Andy. I don't want to speak. I don't want to cut off Patrick until you're ready. I just want to be able to express our concerns on each of the points as we go through it. If this is an appropriate time, I will.
Sure, Andy.
Okay. All right. I just want to be sure. Our concern are a couple of things. Number one, we were surprised when we saw this declaration of an easement, because it's not something that we ever offered or said that we would do. The concern we have are a couple of things. Number one, this sort of easement would run with the land. So in the future, if there was some other use there, this is now filed with the Columbia County Clerk's office and is like any easement, it's running with the land. Whereas if in the future, this building changed and the usage changed, if we had it as a condition of this approval and a new use was coming in, that new owner would have to come back to the planning board and they'd have to go through the entire process again, like we did, and have conditions put in place. In this particular instance, we feel that, it is private property. We've always been clear that we want to have it open to the public. We're willing to have it be a condition. It is enforceable like any other condition you put on other projects. When you regulate use at any commercial establishment throughout the city, you put a condition on them, and we're ready to have that condition. That's a lot different than creating a property right. And that's what's being proposed here. And so I just want to be clear. It's not that we're walking away from doing what we said we would do. And I did create, Patrick did read it. I did create language that I sent to him in a separate document that you could look at. We're not walking away from it. But to us, filing a property right is a lot different than having a condition. And I think enforceability exists either way. If we suddenly lock all this and don't let anybody in, you can revoke our site plan. We're not allowed to do that. So those are our concerns.
If I could comment, it sort of cuts to the core of the concern the board raised from the beginning, which was very much how do we define a public space? We greatly appreciate your, Pocketbook Factory's effort to revitalize this very important building in the city of Hudson. But I believe, maybe I took charge or maybe took a little bit of lead in attempting to press the applicant in defining specifically what that meant to say it was public space. And clearly, what this language now says is you have agreed that this is public space. And we heard very much early on that this was going to be public space. And again, I trust and respect your view, Andy, that you guys aren't necessarily backpedaling, but this is really the crux of the matter. Like, what does it mean to be a public space? And clearly, if it is a public space, this language we have now seems to work, in my mind.
And that's a very interesting point, Clark, because you did press the applicant on that. The landscape architect for the project gave a series of case studies, many of them in New York City, that operate under New York City's public plaza laws, which I believe actually are easemented, right? That
yes,
public has a right to use the land. And I think what's interesting about an easement, it also does, it goes with the land. Andy's absolutely right, but it also does protect the property owner from any common law claims of open space, right? I mean, you know, at Harvard, they lock the gates to Harvard Yard once a year so that they assert private property dominion over the land, and the city of Cambridge can't claim by common law that because the public has been allowed unimpeded access to the property, that it's public land, right? And the nice thing about an easement is it clearly establishes who the property owner is and gives the public a marginal use of that land as indicated in the easement. So it doesn't just take away from the property owner, it also asserts the boundaries of that open space.
Right. I mean, just to be heard, what we've always said is that we would grant public access. We never said we were going to create this as a public park. We were going to provide public access to our private property. And we're not walking away from that in any way, shape, or form. But the placement of an easement, and again, until 2 hours ago, I never saw this. You know, the placement of an easement, that is basically, I mean, that's granting essentially a property interest to the city without the city paying for it. It's a taking. We never offered an easement. And I mean, the resolution itself, when we look at it, it talks about public access to open space. We are, again, we're not changing that. We continue to offer that. And the concern was, we did have a lot of discussion. The concern the board had, they didn't want too many rules because they didn't want to impair. They wanted people to have a place where they could go. And we certainly continue that. But there's a distinction between that and placing an easement on private property. And that's our concern.
Chair, may I ask a question of either of the attorneys to maybe help direct this conversation?
Yeah, sure.
I've run into this in the past. When you're dealing with property rights, typically that authority rests with a city council or mayor or the executive of the or legislative branch of the city. So I don't know, is this something that the planning commission could do, or does the condition have to be that the city body responsible for property dealings?
I think our attorney wouldn't do it if it wasn't something we could do. But Patrick?
Yeah, in this situation, the city common council would eventually sign off on whatever easement would be granted. And I'd also just like to state that public access easements are often given for these types of projects where it is understood that the public is meant to have access to these types of spaces. And in this type of situation, I think having a separate document is also very useful because we've been trying to nail down what exactly this public use is and where it would be. And having just a sentence as a condition in your resolution is enforceable. However, there's ambiguity there that has not been fully fleshed out so far. And I might not feel comfortable recommending you approve a condition that just says for public use and passive recreation, when we're not entirely sure what that would be. Whereas if we have an easement that can be very clearly fleshed out, this right to exclude during non-daylight hours and during special events can be made very clear. Andy, I'm sure you have thoughts.
Well, before we get Andy's thoughts, Patrick, can I just follow up on a question relative to Andy's point? You know, an easement goes with the land. What if, say, the hotel sells the property to a different private developer who wants to create low-income senior housing, and they have concerns about the public encroaching on the safety of the seniors who are living there, but there is this easement? What happens in that scenario?
Well, are you talking about there being a change in use in that situation?
Yes.
Okay. They would come back to the planning board for a new or amended site plan approval, as Andy alluded to. And in that situation, I believe that the easement would be readdressed by the planning board and by the city. And if it was no longer necessary, or is no longer serving any purpose, I believe that the city would reevaluate that at that time. Moreover, if the project is eventually changed, it could be that this that the public would no longer have a desire or need to access this space. Sorry, Clark, were you about to say something?
Oh, sorry. I guess I had a thought, which was, it's useful to understand what that process would be to sort of revoke the easement. But it seems, not that it's irrelevant, but I think it's sort of like cross that bridge when we get to it. It's very important to understand what that is, but that could be decades down the road or never. And I feel like we should address the issue at hand, which is the applicant. You know, again, we're passionate out here what this means to have a public space. And I think we should address the immediate issue now. And again, they're going to put many millions of dollars into this building. I doubt that this issue is going to arise anytime soon. And I think that we should make sure that this board is comfortable with the definition of what that access means. So I not that this is irrelevant, but I think it's not our key concern right now.
Well, relative to that, Patrick, I have another question about procedure. Do you, I mean, you know what we're facing in the next other 4 bullet points, as well as the bullet point that doesn't exist yet on acoustics. Do you think it behooves us to go through all of the conditions and then vote up or down on the entire resolution? Or do you think it's imperative that we address each one of these matters and get a sense of the board on the resolutions, on the conditions as we move through them?
Well, in any case, the board is going to have to review the conditions individually.
Right.
I think that in a situation like this, it's unfortunately going to require a significant bit of discussion for each and every one. If you think that it might be better to acknowledge that we've had a discussion on this and table it for the time being for the sake of moving forward, that's up to the planning board.
Can I make a suggestion?
Sure.
I was thinking about public spaces in New York City, which I'm familiar with, and Bryant Park comes up, and obviously it's a different beast because it's a big public space, but it's a public space that had some controversy relative to it being used by public entities, including an annual fashion show. So I know there are
private entities.
There are public spaces with bylaws or whatever, you know, that have maybe it's amends the notion that this is just 100% public space and that there are events that happen here that are very private. And I'm wondering if that model it would be useful here, where I'm just throwing this out there as an idea, the easement is granted, but the applicant or the owner has X number of times per year. I know the applicant has also said we're not doing big events and we're not regularly, and we're not an event space. So they have clearly stated that there's not going to be many of these. Maybe the condition says, yes, the easement is granted, but per Bryant Park example, there are private events that happen in this public space, and we can define what those might be. Again, maybe it's a half dozen times a year, maybe it's 10 times a year, and the owner of the property has right to this easement or this space, which has a public easement.
Patrick said that was possible in the easement. Patrick had already, right, Patrick?
I believe so. Also, I was refraining from bringing this up because it is a different discussion that I believe Andy and I would have to have outside of this meeting. But there are instruments that could limit this public right to a specific time or to the specific use, such that in the future, if the use did change, the public access right would be eliminated. And Andy,
Patrick, would that happen in the drafting of the declaration of easement?
It would be written into the instrument itself.
And does the board review that instrument at some point, or is that a private negotiation that's then taken to the common council for review?
Well, it can go a variety of ways. The way we have the language drafted at the moment is that the board wants to ensure that there is public access to open space on the property. And in order to do so, it has kind of delegated ultimate approval authority over to its counsel. So its attorney would then receive a proposed easement from the applicant. We would review it, go back and forth, and make sure that its terms meet the language that the resolution intended it to meet.
And just so I can be clear, we don't have a problem having those conditions spelled out and having them in writing. And if there's an enforcement mechanism that you want to have incorporated in that, I mean, that's something that we would need to do with the planning board's attorney. Our concern is, creating this property right and filing it. And it just doesn't seem necessary here in the sense that we can provide for the public access that we've talked about. We can provide for the parameters that we've talked about in terms of hour of operation. And we can talk about specifically what happens if we fail to do that, and get this planning board and its attorney to approve that and not go through, really the granting of a property right to the common council, because that's, not something that we've talked about in the last 6 months. Public access to the site, absolutely. Written agreement, spelling it out, absolutely. You want to have penalties if we don't do it. We're fully comfortable that we're going to do this. Fine. But it is a bit unprecedented to have an easement such as this on private property, particularly where the applicant had no legal obligation to do that. And again, isn't running from it, but is now, being told they have to give up a property right. And so that's our concern. Having something in writing is not a concern. It's really the filing mechanism and having it be essentially an easement on the real property that really doesn't go away. I mean, I know the board may not care about it, but that private property owner does, because if the city later decides, no, you don't want to get rid of it, in Larry's example, we have no way to get rid of it. And that's a problem. I mean, it's a problem for us.
Patrick just explained that might be, the way it's languaged. The thing is this, as Patrick has mentioned, and I think maybe it was Clark, we really never, part of the selling point of the pocketbook family, the pocketbook factory has been this idea of the public's open public space. And it's something that Sean and the other people involved have talked about from day one, but yet and with much enthusiasm, and not just to the board, but to the public.
Sure.
But yet it really truly has not been defined. And, so for us to come up with a condition, it's pretty difficult, Andy, because we really don't know what we don't really know what the plan is for the public space. And I just want to repeat that this is a neighborhood, it's a residential neighborhood. It's a little different than some of the other applications. And it's a hotel, where people aren't going to be living here. They're coming, they're going. They might come back because they like Hudson, they might not. They're not invested here, but the people that live in that area are. And I think that's one of the reasons why Sean so wonderfully is said that this, this is a public access is one of the major things that they're doing.
No.
But we do not really, it's not something that has been emphasized in any planned way to us. And, I don't know how we go forward with that. I wouldn't even know how we begin to put conditions on something that we don't have a plan, we don't have a plan. We haven't heard what the plan is.
But
Laura, may I actually respond to that?
Sure.
Yeah, and I mean, thanks for recognizing that it is important to us and that we've been consistent in our desire to, rehabilitate the entire site and make it available to the public and really bring back something that has been gated and closed off for 40 years, because that is the scenario. And really the contrast in what we're doing is, investing an incredible amount of money in the restoration of this building and the landscape around it. And as Andy said, we are willing to commit to operating in a way where we can set conditions with the planning board. And, I think we have actually created a pretty in-depth plan with our landscape architects, Hodgson, Wagner Hodgson, and we've presented that over the course of 7 months with you guys. So you've seen planting
Right,
plans.
Sean, but the
You've
reality
seen
is that
pathways.
Sean, this is now the point at which we have to determine what that actually means legally, right? And kumbaya pictures are different than the words of the law. Look, we've already been on this about an hour. We still have 4 more conditions to review. I propose that we table this conversation, understanding our reservations, I think our collective reservations, and then see how far we get in terms of whether we're able to reach some level of agreement across the bulk of these conditions.
Yep. And Larry, just really quickly, just to be clear, what we've always said is public access. We want to have it open. Passive recreation, remember, where people can go and enjoy the space and can just be. We're not going to put overly stringent rules on what they can do there. And I understand the board's concern. You want something in writing to make sure we do what we said. We will do that. The issue is hearing now that suddenly isn't being approved by the Common Council. That's it. Okay.
Thank you, Andy. Thank you. Patrick, can you take us to the number 3?
Sure. Next one, speaking of easements, approval by the planning board attorney of an easement or agreement granting the applicant use of off-site parking facilities sufficient to accommodate increased demand in parking during special events held at the property, along with an undertaking from the applicant's attorney to record the easement or agreement as soon as the site plan set is signed. I spoke with Andy about potential conditions, and he also provided a comment on this, stating that he would rather the language say something along the lines of the applicant shall provide off-site parking facilities and a shuttle to bring guests from the site for any private event hosting more than 75 people. So it's setting a actual numerical threshold. It would also have the applicant file proof of having said off-site parking facilities in the form of a written lease or other written agreement to be filed with the City of Hudson Code Enforcement Officer. And that would have to be filed at least 10 days prior to any private event hosting more than 75 people.
Patrick, what's your recommendation on that?
So in this one, we acknowledge that trying to arrange for an easement over separate property for the use of parking that would run with the land and basically keep going throughout the life of the property might be a bit much to ask of the applicant in this situation. So that's why I included the language or agreement granting the applicant use of offsite parking facilities. Essentially, we just want to ensure that in the event that they have these events, that we know where the cars are going to go, and we want to have proof that they've made arrangements for this in advance. So
can we just strike the words? What would happen if we took out easement or and just said proof by the planning board attorney of an agreement granting the applicant, and then later on to record the agreement? Isn't that essentially
what? That would most likely address a number of Andy's concerns, I'm sure. And in that situation, I think that the planning board could still feel comfortable knowing that the applicant needs to arrange for these parking facilities in advance, and we will be making sure that for these special events, they won't overwhelm the area. So it could be something along the lines of
What?
And then in that case, an agreement most likely would not be recorded, not with the county anyway, but we would require that the agreement be filed with the office of the planning board secretary and the code enforcement official.
So you'd also strike the second time that appears, right? Record the
yes, I would
last
rewrite
sentence.
that. Yes.
Or what's your opinions about this?
Well,
Are you asking me or the remainder of the board members?
The
And
board.
I asked the board members.
I have a question.
Yeah.
He said 75 people. Are we not going to honor that, or we're gonna put our own number in?
Well, this language doesn't have Andy's number in there. Do you?
I mean,
want a
are we
number in
not gonna put a number in there, honor the 75, or do we have our own number? Why 75? I mean,
Yeah, that number came because that's the figure that's used for any mass gathering permit in the city.
okay,
And I think we talked about that previously. And
Yes,
the
we
reason
did.
why, yeah, the reason why we suggested that language is because I believe Sean talked about it. I mean, they currently don't plan on having any of those large events. And what they pledged to do is that should they get to a point where they have a one-off, or, you know, they have something along those lines, that they will fulfill that pledge to provide proof that they have, you know, a written lease agreement or other agreement to shuttle people to and from the site. I did add that language too. They'll bring them in, they'll take them out. You know, we thought, again, to make sure that it was clear that it would be filed with the code enforcement officer. I mean, if you want language that says, you know, with the approval of the city attorney, obviously that's fine as well. But then this just allows them to, if they're going to do it, put it in place. Because otherwise, you know, having an easement is pretty difficult.
And I'd like to acknowledge that, speaking of parking, Lindsay might have something to offer.
Well, I'd like to offer that even though it's allowed to be 75 in that area, I guess my question is, if even if it was 50 people,
it'll be a lot.
it would be a lot. So, because we already have a parking issue there. So I don't know, 75 seems like it's not, you know, that's too many,
Too high, you mean?
too high.
Yeah.
Yeah,
where's
so you-
Lindsay's here with us now. Lindsay, can you counsel us here?
Yeah, and hopefully you can hear me. I just don't have video tonight.
Oh, we
Yeah.
can.
All right. My only concern, and I know the expectation is events are going to be limited. My only concern would be events that run past midnight. That's when alternate side parking is in effect and when parking is significantly constrained. So I might offer to the board a suggestion of altering that number to be lower, a lower threshold if the event is going to run past midnight.
Yeah, that's a really good point.
What would be the lower number, Lindsay?
I'd have to go back to the actual numbers to define like what that parking capacity might be. You know, we're at the 85% threshold. Events are going to be rare. You know, perhaps roughly half the number, you know, 40, 50, something like that.
Yeah, I would say 40,
But it
41.
would be only if the event runs past midnight.
Why midnight? People park their cars before midnight, don't they?
But at midnight,
Yeah,
yeah, sorry.
you can go ahead, Larry.
At midnight, the parking crunch happens, right? Because you can park on both sides of the street before midnight, and then all of a sudden at midnight, we lose half our spaces.
It says that, the sign says at midnight, or does it say 11 PM?
It's midnight.
Oh, it's midnight.
Midnight to 8 a.m.
Okay, gotcha. Yeah, I would agree to a lower number,
I think 40.
41.
41.
For
Yeah, they
event-
got parking spaces for 40.
for events going beyond midnight.
Yeah,
And then Patrick, I think we should add what Andy had said about, you know, busing.
Coming and going.
And out, coming and going, yeah.
definitely. I agree.
Would sure be nice if the public could be made aware beforehand that this is going to be happening. Is there any way that can be done?
I would envision, Laura, because again, these are going to be rare events if they happen at all, that would be part of the process, that anyone who received an invite would be told, meet at this location for a shuttle that'll take you to and from. Yep.
Right, but could the people that live in the area, Andy, be made aware that, you might have some parking issues or, I don't know.
Well, hopefully they won't, because we'll be shuttling people, right? So that should work.
Oh, I'm sorry, put more than 40, so that means 41. Right, okay.
You're so funny, Jason.
Well, I just, I have to make it for the simple people like me.
All right, let's continue and get a sense of the whole picture before we go back to this language.
Sure.
Patrick, can you do number 4?
Yes, moving on to number 4, I think this is a fairly straightforward one. Applicant shall purchase 40 parking permits from the city of Hudson for guests and employees. Upon speaking with Andy, he wanted to add language that they would purchase 40 parking permits on an annual basis to reflect that they'd have to re-up each year. He also wanted to add the following sentence. In the event applicant secures fixed parking spaces totaling at least 40 spaces, applicant shall not be required to purchase parking permits from the city of Hudson. Essentially, if they don't need the parking permits anymore, then they don't need to get the parking permits.
So if they find
I think it's a reasonable request.
Sounds good to me.
that makes sense.
Mhm.
So if they are able to purchase a parking lot or make a parking lot, then that has at least 40 car spaces, they don't need the permits anymore. That's fair.
So keep buying spaces every year.
Okay.
Yeah, that's good.
Number three is confusing, so I know you're gonna change that, so.
Yeah, we're gonna go back up to it.
Oh, yeah, we're going to clean that up.
Yes.
All right. Shall we move on to number 5?
Please, let's.
Before we go
All
back, can we go back to that one with the parking spaces?
Mhm.
Sure.
The way I understand it, the city issues parking permits for parking tickets. The only place they rent spaces out and get a permit for is the Amtrak parking lot. In the municipal lots, it's only for the event of getting parking tickets, that if you have a permit, you don't get a parking meter violation ticket.
Gene, we had a
Go
for
ahead, John.
620 Union Street, we had them get permits in the city lot. And they had talked to Tracy and she seemed to have no problem with that. And I would assume this would be the same kind of thing. Where they actually got, I don't know what they'd be, hanger cards to put on somebody's mirror or something like that, to show that there's a permit for a parking space in this lot. There was no mention of tickets or anything like that when we were doing the write-up for that.
Okay.
And I don't know, you're coming at it from, the police department angle. You might know something I don't, so.
Yeah, that's the way I understood it, that the only rented space is for the Amtrak parking lot, but the municipal parking lots, the permits are issued for freedom of a ticket, so to speak. And I had asked Tracy that like a couple of weeks ago,
Uh-huh.
and she said it was for parking tickets, not to reserve a space.
Well, I don't think we expected when we did it with 620 Union Street that it would reserve a specific space. It would just be a thing where, they would have the ability to give their guests a permit to park in a city lot.
Basically,
I
they're
don't-
prepaying the meter with the permit.
Basically, yeah.
That's our understanding. If we're wrong about that, then we've
Okay.
Yeah.
we've been talking about projects for months in the wrong way.
Not just this
That's
one.
right. And I think that's right. And I think Gene's right in the sense that it's important to make it clear, like, we'll have these permits, but that doesn't mean for city residents that we're blocking off 40 spaces in the park. Like, it's a fluid situation. So,
Right.
but we'll have a permit where they can go there, but they don't, the Pocketbook Factory does not own a parking space.
Right.
And what we did confirm is that there, and your traffic consultant did likewise, there are enough open spaces so that we could purchase these permits and there's still other spaces available for members of the public.
Right.
Can I ask a question? Would that include parking at meters on the street also that permit?
No, I think it's just in the lots.
Oh,
For the
just
lot.
lots.
Just the
Okay.
lots.
I guess, but Andy, are you saying, I mean, in other words, even though there is on-street parking, wouldn't, is it the plan to use up these permits that you have? You know, or wait until there's no more parking on the street and one of the customers says, geez, there's no place to park, and then give them a permit? I don't get it. How's that gonna be managed?
Yeah, no, under the parking study that we did, we would be providing that to patrons of the hotel space so that they would have a fixed place to go and have a parking space, taking them off the street.
Okay.
That's every room, right?
Yeah,
Every room.
Yeah, and additionally, including messaging when anyone would confirm a hotel room that, here's the parking procedure and that we have permits available and here's the location of that lot.
and I can tell you, I've been to certain cities where that's exactly what happens. When you go and check in, they immediately give you a voucher so that you can go and utilize a municipal space. So you drop your stuff and you go park.
Sometimes there's even a valet that does it for you. All right, let's do number 5. Patrick, can you take us to number 5?
Gladly. Number 5, applicant shall operate a shuttle between the project and the Hudson train station for hotel guests and staff. Now, this condition has kind of been pushed up into number 3. And Andy had suggested that the condition be used instead to address shuttling for construction workers. Now, it really depends on what issues the planning board is trying to address by requiring the shuttle. I think in this case, we would be covering guests going to and from the other parking facilities. Andy is suggesting having the shuttle for construction workers during construction. I guess the only other question is whether or not the planning board also wants to have a shuttle operating throughout the project's operation between the project and the train station.
But wouldn't the construction workers use the same 40 permits that are in number 4?
Yeah, no, and if I can explain, because I thought maybe there was some confusion, maybe there wasn't, but what we had represented to the board during the process was that during construction, we had secured an offsite location, if you recall, where we would be bringing the workers in on a daily basis when they're working on the site, so that there's a minimal, impairment to the neighbors. So they're literal, there's not a lot of obstruction. And I just didn't see that anywhere in the condition. So the idea was, if you recall, they were going to be bussing in those workers. They would work the day and then they would bus them out. And that wasn't contained anywhere within the conditions. With regard to, the shuttle, I think as Patrick said, we feel like the parking permits have addressed that, number 1. And number 2, somebody getting off the train, I mean, they can certainly take an Uber to come up, they're not going to have a car. So we've addressed the issue with those that do. Those that come by train will take a taxi. They're not going to have a car to drive to the Pocketbook Factory. So that's why we suggested the change.
Well, I agree with that, because if they don't have a car, then we don't have, that's not an imposition on the community. But I do think that it should be a condition that during the time of construction, that the workers are shuttled in and out. There's nothing wrong with that being a condition just for that period of time of construction, right?
Right. No, we suggested it.
Yeah. So we can make that. Yeah, I don't know that. Yeah, I just don't know that we had considered it being a condition, but I think it'd be fine if it is.
Great. And I see no reason for the government to require someone to have a shuttle. You want to make your guests' experience a more luxurious and wonderful one, you make a shuttle for them. If you don't, then they schlep on their own terms. That's up to you.
And the only other language we had in 5, it was similar to 4.
Andy, let our lawyer guide us through 5 and you can weigh in. Can you?
No. What Andy
5. Okay, sorry, Andy. I'm very sorry. Sorry, Andy.
What Andy is referring to is that requested that there be a sentence along the lines of this one.
Oh, yeah, no, that makes sense.
Such that, if they have offsite parking and they don't need a shuttle, then they wouldn't
Yeah.
need to operate the shuttle.
Talking about for the workers?
Yeah, just during the construction phase. So if during construction, we secured a space where we could park the construction workers, we wouldn't need the shuttle. If we don't secure that, we obviously do.
That's assuming that the spaces you secure are close enough that the construction workers could then just walk.
Right.
Where would that be, Andy? Where would that,
Just copy paste it down. In the event the applicant secures fixed parking spaces, comma, doesn't really matter how many.
Oh,
applicants-
I think Laura was asking where physically could there be those spaces?
Oh,
Yeah,
We are looking at potential spaces in close proximity to the pocketbook factory. Across, basically, just down the street.
and that's not gonna impose on another community or another neighborhood?
No,
How do you know? I mean, I'm just so curious.
no, but because it's an open lot. I mean, we talked about that. There's vacant city land across the street, farther
Oh,
down
that land.
Washington Street. Yeah. So if, and it probably won't happen, but if it did, and we could have them park there during construction, the same rule would apply.
okay. Patrick, with apologies to Andy, could you take us through item number 6 now?
Sure. The applicant shall submit a sound attenuation plan to mitigate noise impacts from outdoor events and demonstrate compliance with the City of Hudson noise ordinance, the form and substance of which shall be approved by the engineer to the planning board. And then I added the following sentence based off of our discussion so far tonight. The project must comply with all applicable regulations of the City of Hudson noise ordinance. So the goal of this was to allow the project to get a conditional approval with the understanding that they're still going to submit a sound plan that is going to be reviewed by the planning board engineer to make sure that this plan is doing what it's supposed to do, which is mitigate those impacts and ensure that the project will comply with the code. And then as just a belt and suspenders type of move, I've added that they are required to comply with the applicable regulations, even though they would have been required to comply with those in any event.
I want to say that sound is part of my field, even though I don't completely understand it. And I think that it needs to be a sound engineer. I'm not comfortable with the engineer to the planning board. In other words, do we get to choose a sound engineer?
Yeah, I would say shall be approved by an acoustics engineer to be determined or to be selected by the planning board. And I wouldn't say sound engineer because that's the guy behind the board at a recording studio, right? I would say an acoustics engineer to be selected by the planning board, or an acoustics expert or an acoustics consultant. And I don't think we necessarily need to decide right now who that's going to be. I mean, that might be Aaron or his firm, might be someone else. I think that the critical thing is that if we're able to, we give the applicant provisional approval, and then we work out the specifics of the sound attenuation, when they come back to the plan.
I think acoustics engineers is a good term, is the right term.
Aaron, I'm not an engineer. Can you please confirm for me whether or not acoustics engineer is like a term of art in the field?
It's a term I've heard used, but I think an acoustics consultant would be better terminology. You don't necessarily, experts in this field would not necessarily be professional engineers as defined by the state of New York, but would still have the expertise to weigh in on the subject.
Boy, there is a big field of in acoustics engineering, so. Okay, so I'm looking this up, and again, this is just on my phone, and I'm not doing a deep search. And so I see the title here, acoustic engineers / consultants. So how about that? That covers everybody. Acoustics engineers / consultants.
Okay.
To be selected by the planning board.
Yeah.
Patrick, you got that?
I do. Any other comment?
Board?
Yep. But I also would like to see, do we want to discuss, you know, end times for during the week at least?
Or outside?
Yes.
Yeah, I agree. Where would we discuss that now? Now?
Yep.
Yep, because these is when we're doing the conditions, and if somebody could go through what the code says about it, because I can't remember. Is it 10 o'clock?
10 to 7, I think is the code rule.
I believe it was 10 p.m. to 7 a.m.
On Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday?
That's correct.
Oh.
Laura, do you have a specific proposal for?
Well, you know, I would say for Monday, Tuesday, Wednesday, Thursday, you know, like 7 o'clock maybe. And then, you know, just so that, and then Friday, Saturday, Sunday, you know, whatever the code says.
That sounds okay to me.
Remember, it's a residential area.
Well,
At least 95% of it is, yeah.
can we be heard on that?
Of course. I mean, sorry, Larry, can he be heard on that?
Sure.
All right. I mean, what we would propose, there are regs in the code that talk about commercial music. And so what we would propose, and I think we talked about that, would be on Friday and Saturday, the, you know, no noise, you know, after 11 until 7 a.m. and Sunday through Thursday, utilizing the code that says 10 p.m. So it would be no noise from 10 p.m. to 7 a.m. And again, all that noise still has to meet the requirements of the code, even during the times where it's allowed.
Yeah, but you know that the levels that the code allows, if you're trying to get to sleep because you have to get up to go to work in the morning, it's still allowed, Andy. I mean, I think that 10 p.m. on a weekday is really not fair. Again, just remember, this is a residential, generally a residential area.
Yeah, I mean, it's not a residential zoning district, you know, I mean, that's the thing. And the zoning, you know, the zoning code does lay out the requirements for the districts. And we're not looking to go beyond that. We're willing to be in compliance with it. And we're willing to do the sound attenuation to mitigate it even more. You know, but, you know, to me, Sunday through Thursday at 10 p.m. is not that late. And for a Friday and Saturday night at 11 p.m., it's not that.
You know, I want to say, Andy, I understand what you're saying. That is what the area is zoned as, but we're kind of looking at it as that particular block, those two residential blocks that you're going to set your project on. So because of those blocks being a good 95% residential or 99%, I'm going to agree that the music should be cut off a little earlier during the weekdays and on the weekends. Now I live on Worth and I can't stand noise. I mean, at about 7, 8 o'clock at night, especially 10 o'clock at night, but 7 or 8, you can hear a pin drop here. Even though the trucks are coming, they just stop. So it does make a difference.
Yeah, but the concern we have is that, you know, then we're going to have a restriction that, you know, isn't in your code. I mean, you have a very detailed code.
But we can do that.
You do.
That's what we do.
But you've been our lawyer on this board, Andy. That's what we can do. I mean,
We've not shut down.
Okay. What I don't want to have, let's talk amongst ourselves. I don't want us to engage in a debate with the applicant's attorney. We can
Okay.
determine on our own what we want to do. Jean, can you tell me, I mean, you have experience with, noise violations and what it's like for people. I mean, what's your thoughts on this?
Well, it's restricting the applicant to running a business that he's entitled to. In years past, anytime we get the noise complaints, we handled it accordingly. They put them on notice, and if it continued, then they were written up for it, either by the police or the building inspector's office. It's already in the code as to what you can and can't do, and by adding to it, you're circumventing the code, as far as I'm concerned.
Clark, what do you say?
I think that I appreciate Teresa's and Laura's comments. I think there's room to scale it back a bit. I don't think 7 is reasonable. I think 9 is reasonable. So perhaps splitting the difference. I do appreciate these guys. They've got a business, they've got private property rights, they've got the code governing them. But I do think that as it's a commercial or a residential neighborhood, 9 o'clock during those weekdays seems fair to me.
Patrick, what's your experience here? I mean,
You forgot John.
oh, John, sorry. What's your thoughts on this one?
I guess we could do it. My lean would be to go with the code, to be honest with you. Because I have a feeling that there aren't going to be a lot of loud parties there at 10 o'clock at night, or probably even at 9 o'clock at night. But, just my thought. I mean, I live in an area where I listen to the Basilica, and sometimes they're doing it till 10 o'clock at night when there are bands down there practicing and stuff like that. Stuff on the waterfront. You have a tendency to block those things out. The problem would be with residential neighborhood with kids who need to get to sleep at night before, a school day or something like that. That could cause a problem. So, but, I think based on what, Andy and Sean have said, they're going to be pretty attentive to it. So, I'll go with an earlier time if everybody wants it, but I think, the regular code hours would work for me.
Okay. Patrick,
Call Steve.
Patrick, in your experience, is it common for a planning board to set a condition that is more restrictive than the code when you have a commercial enterprise in a residential neighborhood like this one?
A planning board definitely can. I'll just remind the board that your guiding rule in all of this is that your conditions need to be reasonable to address the impacts of the use that might be harming the neighborhood. I will also point out that noise is always thorny, and it can be hard to define what is a nuisance, what's not. Even if we do establish that they can't have amplified music past a certain time, the fact that the code is allowing this means that literally anyone else in the neighborhood could still do that. So it's not guaranteeing that the neighborhood will be insulated from sources of noise. I also would point out that we don't want to, interfere too much on what the code has established. Those are guidelines based on, the Common Council doing a close review of what they feel is appropriate and necessary in certain areas. And people and applicants will purchase property with an expectation that these are the restrictions that they need to meet. In any case, I'm sorry, this is rambling. You certainly can limit hours of operation, especially for certain noise producing events. I would just remind the board to really limit its restriction as much as it can in order to address the impact here.
So if it was limited to 9 o'clock during the week, is that you know, is less restrictive than, is that too restrictive? I mean, we're reminding everybody that this is a residential area where, as somebody pointed out, you know, children have to go to bed and get up in the morning at whatever time children get up. And it's an organization that plans to be good neighbors.
Well, I would probably ask the applicant, based on your business model and plans of operation, would a 9 o'clock restriction severely hamper you?
Sunday to Thursday.
Yes.
So there's plans to have a lot of noise till 10 o'clock during the week, amplified noise outside during the week.
I'll chime in. You know, I think it's as we've been consistent all along that, you know, we are not planning on having a loud outdoor events venue. That isn't our business, but we feel that, you know, just being treated the same as everyone else in the code and just kind of following what our government has set out is what we would feel most comfortable sticking to. I definitely appreciate the perspective, Laura and Teresa, and that everyone has shared, but yeah, I think that's sort of where we're at. Yeah.
This also this is only going to include that public space, right? The outside area that can be used for the
exterior amplified noise. You know, I think the proposal, if I understand Laura, is to restrict exterior amplified noise to hours must end at 9 p.m. on Sunday to Thursday. Is that what I'm understanding?
You're kind of cracking up, Larry, but I think that's what I'm saying.
And I'm sorry, just to be clear, what we're seeking would be the code provisions of Sunday through Thursday, 10 p.m., Friday and Saturday evenings, 11 p.m.
Okay, board, what do you want to do?
I think you vote on it, right?
All right, Laura, can you set out what you want to, the wording for what you want to do?
I mean, I'm not making a motion. We'll just.
Oh, I know, but are you suggesting that we do?
I'm suggesting that that from Sunday through Thursday, I'll change it, my idea, to 9 to provide for children to be able to go to bed and get up in the morning to go to school. And it is a neighborhood. I just want to remind everybody. And then, of course, the, for Saturday, Friday and Saturday, the 11 that's already allowed. That's what I'm proposing.
Okay, let's take a vote. Clark, what do you say? Yes or no?
Yes, that seems fair to me. I agree.
Okay, John?
That would work for me.
Teresa?
Yes, I agree.
Laura?
She already voted.
I agree with what you said.
Jean?
No, stick with the city code.
Larry?
I don't like restrictions on businesses. I'm gonna say no because yes wins. So it's 4-2 and we restrict it at 9 o'clock.
Okay.
Patrick, did you get that?
Yes, so the condition that you'd be proposing is something along the lines of exterior amplified noise.
Yeah, exactly. Exterior
shall
amplified.
not be permitted after.
this would also cover that the part that's being used as public space, because you'll put a sign that no noise, right? In other words, the area that's being used for public, you'll also probably put a sign there that tells, no amplified music or no amplified noise after 9 between these hours.
I think the public is not there. I think that the public, right, Sean, it's the public access ends at a certain hour, right?
Well, that depends on the declaration of easement. Can we go back up to that one? There?
Sure. So the original point of contention, I do understand where Andy is coming from, especially being concerned about a right that does run with the land even after the property is sold. However, we do want to ensure that if this applicant decides to sell his business to someone else, that the planning board can still enforce these provisions against that subsequent owner operator of the business. So an in-between might be something along the lines of changing the phrase declaration of easement to written instrument. That way we do have a instrument other than just a sentence or two in the resolution that more clearly establishes what public space we're talking about and what is being offered. And that also grants a little bit more leeway for Andy and my office to try to come up with something, whether or not be a license or temporary easement or something along those lines, that still will ensure that there is this public access space, but it would hopefully alleviate some of the owner's concerns.
Well, I appreciate the sort of Solomonic suggestion. Who vets and gives a thumbs up, thumbs down to this so-called written instrument?
That would, as drafted, it would be my office.
Right. I mean, you'll draft it, but then who's to say that you didn't, I don't know, sell the company store or get a bad deal or get, blindsided or coerced or worse. I mean, how do we ensure that the public's being protected here? I mean, I like the notion of a written instrument. It's less burdensome than an easement, but how do we know, whether it comes back to us or the common council? I mean, is there some public body that can see this thing to be sure that it's the intention here?
I'm trying to just say, sorry, Patrick, I'm just going to interrupt. First one, I think that temporary easement is maybe a good phrase to explore. And in reference to what Larry's talking.
Laura,
you've muted yourself.
I don't know how I did that. Okay. What did you hear? So I think about that term temporary easement, because that might work, but you work that out with Andy. But is there a way that whatever it is that you and Andy work out, your office and Andy works out, it could come back to us for approval?
We could try to arrange something like that, but at that point, I don't think it would be worth having a conditional resolution that got adopted tonight. I think it might be more beneficial for Andy and my office to consult in between this meeting, the next meeting, try to get that ironed out, because it would just be coming back to the planning board anyway.
Well, then could I make a proposal, Larry, that that's what happens? And then at our next meeting on the 18th, a special meeting, hopefully we've seen everything before that meeting, whatever Andy and Patrick's office works out. And all we have to do is a simple vote.
To confirm, do you mean November 18th?
Yes, we have a special session scheduled for November 18th.
Okay. Andy, I'm sure you have thoughts.
But before we do that, thank you, Patrick. Let's not do that yet.
Okay.
So board, I think the suggestion here is to allow the applicant and the planning board's counsel to develop the terms of this so-called written instrument, whether it's temporary easement or some sort of agreement, and bring that back to us at the special session that we have scheduled for next Thursday, the 18th. Are we in support of that? I mean, I don't mind doing that. I mean, Steve's going to chair that meeting, thank heavens. I just would not want us to have to review the conditions all over again, right? I mean,
Yeah, no, it would just be for this one, and also hopefully we will have seen it before that meeting, so that anything that we wanted to add or question is done prior to the meeting, so we're really not taking up time at that meeting on this application that we right, guys? I mean,
right. Patrick, can your office do that? I mean, it can't come to us at 3 p.m. on Thursday.
Yeah, I want to just clarify one thing. So the board wouldn't be making up its mind on the instrument in between this time. We would still have to look at it at that meeting and see if that's what we wanted to approve in the public
we
meeting.
wouldn't vote on it, but we can look
Yes.
at it.
No, I'm just clarifying the record.
I'm sorry,
So in terms of getting it done with a little over a week turnaround, I think I would ask Andy if this is something that he thinks we can try to put together. Andy, you're muted. So,
Yeah,
Larry,
sorry.
I didn't mean
No,
to
yeah.
hand it off to
And
Andy before you were done.
Yep. All I was going to say was, we would be in agreement with the written instrument. The one thought I had, knowing that the board is busy, you do have your attorney. He is representing your interest. To the extent we were able to reach an agreement between Patrick and myself, and he individually shares that with you board members and gets your approval, ultimately he's going to have your approval or not. And I trust he's not going to prove something if you all tell him not, so that we essentially can do the same thing without you having to bring us back and us having to come. And you also can assure yourself that you've each individually reviewed it privately with your attorney and approved it.
But if there's concerns, Andy, wouldn't you want to be there to hash out concerns? If the board raises issues relative to, us reviewing it in advance or live next?
I just think that, we can certainly do that, but my thought is that, ultimately, your attorney's representing you.
Right.
We do have, we're willing to enter into that written agreement. I think we've demonstrated we're willing to put in, terms that are clear and fair and recognize what the spirit of the discussion has been. Certainly, if we couldn't reach that agreement, that could be an issue, but I just don't see that being a problem. And I think you can all have independent input with your attorney and we can get this done. That's just my thought.
Yeah, I think I like Patrick's suggestion. Let Patrick, why don't you and Andy work on whatever the terms of this written instrument is. You forward to the board. We have chance to look at it, and we ultimately clarify the wording of this final condition and are in a position to vote up or down on the entirety of the resolution to approve at our special session next week.
Okay.
Board, are we in agreement with that?
Sounds good.
yes.
Okay, then at that point, we are very close, but we didn't quite cross the goal line. I've been watching football when I work lately, so excuse the football reference. All right, I gotta find the agenda now. Okay. Thank you, applicants and public. That was over an hour and a half. I think that was necessary, and I appreciate everyone's forbearance. That's an important project for the city in a range of ways, and I think that we're doing our best to make sure that we honor the applicant's interest, but also protect the public's interest. All right, our next public hearing is a public.
Larry, before you start, we should probably do a motion to continue the public hearing on the Pocketbook Factory.
Well, we closed
Right.
the public hearing,
We
right?
did. Okay, all right.
Patrick, do we need any, we're about to lose you regardless, right? So do we need to do anything?
At this point, I don't think we need to have the public hearing open.
Okay.
We have a pretty good idea of what we're going to do moving forward. And I don't think that's really going to change. I don't think we're getting new materials or anything.
Right, but in terms of moving on to the next agenda item, is there any, motion we need to conclude our discussion on this project this evening and move on to the next one?
Oh, no, you can just move on to your next application. You've already moved to close the public hearing.
Okay, well, thank you, Patrick, this evening. Sean, Andy, if Andy's still here, thank you so much for your patience. I think we made some progress.
Great.
All right,
Thank you.
so our next public hearing, and thanks, John, too, for keeping me relatively on track.
Larry, actually, sorry to interrupt. Did you need me for 26 Warren or no?
Yes,
Okay.
I'm sorry, but we do.
No, I just wanted to confirm.
Okay. Coffee break, I suppose.
Yeah.
All right, so our next public, are you suggesting, as Patrick, do you think Patrick is suggesting that we bump 26 Warren forward?
I agree.
Patrick, are you suggesting that we revise the agenda to push you forward so that you actually can go back to your family?
Not just that, but to make sure that we're, conserving resources.
Right, yeah, exactly. I like that. Okay, board, with your approval, we'll move to item C and do the continuation of our public hearing for 26 Warren Street, which is a site plan approval for change of occupancy from R3 to R1, changing the use from a single family residence being used as a bed and breakfast to a hotel. The property is in the central commercial zoning district and is a permitted use. We all got a memo from Patrick's office, and I think before we ask for any commentary or updates from the applicant, Patrick, maybe you could just update the board on the memo, and you might want to do a screen share and show us what you've got.
If you don't mind, I'm going to refrain from sharing the memo because it is confidential communications between us,
Okay,
giving you legal advice. However, I will address a general issue that's been brought to our office's attention, which is that this is a pretty unique project, and it's not your typical type of hotel. And from what we understand, some members of the planning board were unsure of how well this fell within the definition of hotel. And I wanted to just state that if the planning board wants further clarity on that, there is an avenue set forth in your code that allows you to directly request an interpretation of the zoning law by the Zoning Board of Appeals, because they're tasked of being the ultimate arbiters of what is and is not a hotel, among other things. So you could certainly do that. They would have to schedule a public hearing and ultimately get back to you.
but my understanding is that the definition of a hotel is fairly clear, right? If people are sleeping there,
Yes, the definition is
profit off their sleeping there, then it's a hotel.
Yeah.
If they're sleeping there, it could be a B&B.
Which is also a hotel by our code, isn't it, Patrick?
It
No.
is.
It is?
A hotel is defined under your zoning law as a dwelling, parens, including a bed and breakfast, offered for rent, the gross receipts derived from its operation of which are subject to the payment of a sales tax by the state of New York. So basically, if a dwelling is rented and you need to pay taxes on that revenue, it's a hotel.
But then we have other restrictions on a B&B that we don't have on a hotel. Or
Yes,
the
that's
definition. So where does that, where does the division comes? Whereas if it's the same definition, then where does that division come to apply the restrictions that we have on a B&B? Are those restrictions also to be applied on what is considered now a hotel?
No, not necessarily. It's that you have one use, you can have a broad use that have more narrow uses within it that are subject to different regulations than anything else. So for example, you could have a definition for dwelling, or I'm just making this up. I'm not saying that this is your code. You could have a definition of dwelling, and then you also have a definition for 2-family dwelling and for 3-family dwelling. And each of those different subsets could be subject to different regulations.
Okay, so do
So-
we have the definition of the dwelling of a hotel in our code that
Yes.
separates it from a B&B?
I'd have to double check whether or not there's a definition for bed and breakfast. It does not look like there is.
Where did the restrictions, what are the restrictions? Teresa, can you repeat that? What are the higher restrictions on a B&B?
That, well, they had thrown it under short-term rentals where you have to, I think it's 2 months out of a year, you can do it, turn your home or whatever into a B&B. And if you want to do it all the times, 24/7, 12 months out of a year, you have to live on the premises.
There was an Airbnb law. That applies to.
I mean, I don't, did they separate Airbnb from B&B? I don't know. I can't remember if they did that.
So
See,
I
now
don't-
I'm just trying to find out what is, this 8-room dwelling could be a 4-bedroom house, single-family house that took their double parlor, kitchen, and dining room and turned it into an 8-room hotel.
I don't know, if I only just received this right before the meeting. I had written a note to Craig Haig asking for some kind of clarification. So he did write myself and Victoria, I had CC'd to her back. And so I don't know if this is helpful, guys, but I'll read it. And I have to actually use a thing because the print is so small. That's not Craig's fault, that's my printer's fault. Hi, Laura. As per New York State Code, hotels are residential structures that provide sleeping areas where the occupants are transient in nature and not limited to inns and motels. I'm not okay. B&Bs are single family residence, owner occupied, and 1 meal a day is issued. Inns can be considered B&Bs as well. Airbnb is not a use identified in the building code. That is a business where owners of residential structures dwellings used for short-term rentals where the occupants are transient. Transient is where the occupants are fewer than 30 days. Does any of this make sense? I hope it does, at least to Patrick.
Laura,
just
could
wanna
you
make-
read the hotel thing again? It was going in and out. The
Oh,
part that you got for the hotel.
It's, all I said is that as per New York State Code, hotels are residential structures that provide sleeping areas where the occupants are transient in nature and not limited to inns and motels. There's nothing in the code that indicates that the owner has to live on the premises for a hotel. B&Bs are single family residence owner occupied, and 1 meal a day is issued. Inns can be considered B&Bs as well. And then there's a whole nother thing for Airbnbs.
So Patrick,
Yes.
given that this applicant doesn't fall neatly into one of those categories, what is your counsel here?
It's up to you to decide whether or not you want to seek an opinion other than your code enforcement officials. It seems to me you have a definition of a hotel, which is a dwelling offered for rent, where the receipts are taxed. If you are still concerned that the project before you might not fall under that definition of hotel, or is not how these, or that it would not be how the zoning law is supposed to be interpreted, you could seek clarification from the ZBA.
Well, guys, it seems as though it falls under hotel because we really don't have a definition of a hotel except for you rent a room and you pay for it and it's taxed. So anything can be a hotel if you rent the room and you pay for it and it's taxed.
The one thing I will note is I've looked in your short-term rental regulations, and it clarifies that a short-term rental is not in a hotel.
So that's an Airbnb, you mean?
Yes.
Right, right. Except for an Airbnb, a hotel, an inn, or a B&B have basically the same definition. Except for at a B&B, clearly somebody lives there and they get breakfast. I mean, we got a code issue, kids, but I guess all I'm saying is that I don't see how we benefit by sending it to zoning.
Well,
I think this might be a situation where the code is not what you expected necessarily, but it is still fairly straightforward.
Patrick, can you help us a bit by telling us again the distinction between R3 and R1? Because really, this is the underlying action here is that the change of occupancy. And what is the R1 occupancy and what is the R3 occupancy? And does it offer us any guidance on how to address the application?
Are you referring to whether or not it would be permitted within those districts, or
what the R1 it does and what the R3 does, and how the move from R1 to R3, what the implications of that are?
I'm not sure if I'm understanding your question. My understanding is the R1 and the R3 are two different zoning districts. Are you referring to something else?
Yeah, the application is for a site plan approval for change of occupancy from R3 to R1, which is single family. R3 is, I think in our code, R3, because I'm an architect, R3 is single family house and R1 is multi-family dwelling.
Yeah, if I may just add, it is a little confusing because there are zoning districts that are also R1 and R3. So it is confusing. But
that's what I
but you said it right, Larry.
Oh,
Right.
I see what you're referring to now. There are use classifications that also go by the terms R1 and R3. I don't have those in front of me. I'd have to check, but essentially you're going from a single family dwelling to a occupancy that's going to be for transient occupancy. So I'm not sure what else to advise on.
It's approved for that district.
Well, you came to us for approval.
No, I understand. It's a permitted use in this district. That's all I was pointing out.
It's permitted with site plan approval.
Correct.
Right, that's what we're doing here.
Yes.
Reviewing that.
Okay, so Patrick, we really need your guidance here. What do you suggest we do so that this applicant has clear direction and we as a board know that we're not approving something that is going to create an undue burden on the neighbors who are suddenly moving next door to a unstaffed hotel?
Larry.
This is not, excuse me, this is not an unstaffed hotel. I think there's been some actually miscommunication about that. And maybe I could help.
Larry,
yes.
Is this still a public hearing?
Well, technically we didn't open.
Should we open it up and maybe the public has questions that we can also put to Patrick?
Okay.
I mean, we may not be the only ones confused here.
Right.
You know, so give him a chance to think about our question and open it up to the public and let's see what they have to say.
Perfect. So board, do I have a motion to open the public hearing?
So moved.
Great. Second?
I'll second.
Thank you, Clark. Ordinarily, when we open a public hearing, we allow the applicant to provide any new information subsequent to the previous public hearing. Does the applicant have any new information they would like to share with the board and the public?
Doug, I would add a few things. Do you have anything you want to add, or you want me to go first?
I don't have anything new to add. I think the application as we presented it last time was accurate, and but
Yeah.
feel free to add.
I agree. It is accurate and fairly straightforward. We're really keeping our ask to a minimum. I think there has been a little confusion. I've heard words like unstaffed and unmanned kicked around, and I did want to address that and any concerns the board has at this time, of course, because I think the board has concerns and they're having, I don't want to put words in your mouth, they're having trouble identifying something that bothers you about my application. And maybe by discussing it, we can get it all out in the open and figure it out together. By way of review, I made it clear when Doug presented this, actually the second time, I wasn't there for the first time, but he made it clear that I also own the Hudson Whaler Hotel at 542 Warren, which is formerly the Barlow Hotel. That hotel and this property share a management staff and myself. I do live at the 26 Warren property, but the management team manages both, and I have dedicated staff at the Whaler, and I have separate dedicated staff at what I call the Mariner, which is this application at 26 Warren. There's approximately 3 dedicated staff, and on top of that, 2 managers plus myself. Far from unmanned, far from unstaffed, and actually, I am very proud of my staff. We're a very professional organization, and anyone who stopped by the hotel, see, I painstakingly restored it to its glory. It is beautiful in there, and it's a public space that people get to enjoy. And the beautiful building at 26 Warren, I'd also like the public an opportunity to enjoy the beautiful architecture and rich history of this 1810 building. It has pumpkin pine floors and very unique architecture. And I think it's a public resource, and I think it's the best use of this property. The fact that it's being run as a similar business now is almost inconsequential, except to the fact that there's been no incidents there. I'm not mismanaging the property. And I have experience running this property very similar to the intended use before you. These things could give you comfort. I am not a fly-by-night operator. I'm a professional. The management staff that manages the Whaler Hotel are actually the former Barlow management staff. I was so impressed with them, and I wanted to give them every opportunity to keep their jobs, and they've more than proven themselves very capable, and the place is running swimmingly and smoothly. So I did want to, I want to welcome the board to ask me more questions about security, ask Doug about the handicapped ramp, but I'm really not trying to go outside the box here, guys.
Okay, thank you for that.
You're welcome.
Do we have any questions for the applicant from the board before we open it up to public commentary?
I just want to clarify, and maybe I'm a bit confused here. At the last meeting, it was clear per your presentation that there are on-site staff at the Whaler. And again, just summarizing my sort of big picture takeaway is that there really isn't on-site staff staffing like a traditional hotel with a front desk, 24/7 clerk or hotel manager. And that was my takeaway from your last presentation. And I would say, in summary, that is, not to speak on behalf of the board, but that's certainly my concern as a board member, that we would be, and again, I try not to be too confused on this hotel definition. My takeaway is that here's a building that's not a hotel now, and you are coming to us per the code for a site plan approval that now turns it into a hotel. And that hotel has short-term stays, you pay taxes, et cetera. But the clear difference between the Whaler and the Mariner is one has, setting aside that it's beautiful and you spend a ton of money and it's a great historic building, one clearly is dedicated as a hotel with staff. And this one is somehow drawing from that staff to manage the Mariner many blocks away. And I know there's been some public comment on from your neighbor that there's a deep concern by the neighbor, and I would say by myself on the board and others possibly that having this new hotel moving, starting essentially a new operation, acting and looking like any other hotel that we've ever been to, except it doesn't have full-time front desk.
Okay. I'm
So
sorry.
that's sort of my comment, and maybe you can correct me.
Yeah.
But certainly was my takeaway from our last.
I don't want to correct you. I just want to add more color so the board has more information at their disposal to make a full decision based on all the facts. The state definition of what is a hotel and what isn't may help you more understand this, and your attorney can probably give you direction on reading that. But I would tell you, as I told you last time, the Barlow Hotel did not have 24/7 staff by any means. The Whaler has most of the day, but they are not there 24/7. They leave around midnight on some nights. Some nights they leave at 10 and they get there around 7. There's other hotels in town like the Howard and the Rivertown Lodge who also do not have 24-hour managerial staff. And for hotels this size, mom and pops, it's prohibitively expensive and not needed, honestly, to maintain a property with 7 or 9 or 12 rooms, to have someone sitting at the front desk from 12 midnight to 7 in the morning, for instance. Regardless, the state law fully contemplates this, and all these establishments, the Rivertown, the Howard, the Whaler, the Barlow, they are all definitely in compliance with the law, and all of them, I'm sure, want to run safe establishments. They have every reason to want to, and everyone is complying to make sure that they have safe establishments. I'm not a one-off. I'm not the Rivertown Lodge. I have another hotel, and I'm able to use the staff from the other hotel to add more of a presence, but I don't have a front desk. But just like this board used to meet in person, people used to check in person, but now they do it over a Zoom call or a phone call or digitally, and it's very much 2021. I'm following the trend. There's people that like the fact they don't have to see a human being to get a key. They like that. Some people value, that sort of experience. They want a quiet, restful experience where they don't see anyone. That's their perfect weekend.
So you have had no sound issues at the Whaler? Doesn't your manager stay at least, his front desk at least is there till 7? And you've had no sound or any kind of issues at the Whaler after 7 o'clock?
What do you mean by issues? I'll gladly answer that.
Well, I mean, what happens at the Whaler, for example, if people staying in the hotel have some issues? What do? There's nobody there after 7, is that correct?
It depends on the night. On the weekends, we try and stay there till midnight to make sure anyone who's checking in gets to see a human. But if they do want to do a check-in virtually and come at 2 in the morning, we're not going to stay there till 2 in the morning. We'll give them specific instructions how to get in the hotel. Now, if you're saying, what if there's an issue with someone being a bad neighbor at night at the hotel? What would they do? They would call the front desk, which by law, there's always someone available, a human at a hotel. That's the law. There's always a human available. And we comply with that law, just like every other hotel. They will call the front desk and they will get a human.
But at this hotel, which is really primarily residential, I mean, in so many ways, there is no human to call.
No, there is a human to call 24/7.
Oh.
There will be a human. They don't have to be
At
in
the
the
whaler, the human is not, that they call is not necessarily there. You're saying at the whaler, they call a human.
at the whaler, just like this application, there's a 24/7 line as per law to get a human being to help you out with any need you have. Okay? At 2 a.m. in the morning, the Rivertown Lodge, the Howard, the Whaler, there's no person sitting at the desk. These are small hotels.
You explained to us last month, right? You have a service that happens in the midnight hours, then that folks call and they get the service, and then the service has the ability to contact.
I remember him showing us his phone that takes, you have a phone system too, where there's cameras in the common area or something, and that's another way that you're monitoring, right?
I do have cameras in all the common areas because that
Right,
makes
let's,
that's a good management.
we don't have more questions for
People
the
don't
applicant.
find that's interesting. Okay, go
We
ahead.
don't have more questions for the applicant. Let's open up to the public. We have a question for us now from one of the members of the public. Let's take that and John Kane, can you?
Chair, as a matter of formality, did we move to open the public hearing?
I thought that we had done that.
Yes.
My apologies if I missed it.
Yeah, we did that.
We did.
Okay.
Okay, John.
Yeah, Mr. Windsor, if you could actually just go through the rest of the process. So,
John,
if
direct
a guest-
your comments to the board. And then the
I'm
board
sorry,
will-
the board, is my question then to the board is, so if a guest is calling to the front desk, a couple of questions. One, is that a hotel employee that is answering the phone, or is that like an after hours service? And two, if someone has a noise complaint, it would be great if they could step out what happens after they call the front desk. What is the front desk action, both at the Whaler and at 26 Warren?
Okay.
How is that resolved?
It's resolved the way it is in every unmanned, digital operation.
We're not supposed to
There
call it
has to
unmanned,
be- Right, I don't want to say unmanned. You see what I mean?
Yeah, no, go on. You're doing good. You're doing
I'm
it.
getting flustered because it seems like we're focusing on something so esoteric. It's just like people come and stay at the hotel, and occasionally there'll be a sound complaint. They call the line. If it escalates to the point where we have to address it, there's always one of the two managers on call with their cell phone 24/7. One of the local human beings is available. It's their job. It's part of their job description. So there's always going to be a local manager. Whether the answering service picks up or not, it always has a live human in Hudson available. So what am I saying? I'm saying the phone call will go first to the front desk. Then it will go to the manager's cell phone. For some reason, if they're out of range, it may go to the second manager's cell phone. At that time, the virtual receptionist could pick it up as well if they see it ringing, just so the person calling gets a human immediately. Okay? If there's an emergency, there's a set of numbers that'll be called. It'll start again with the managers, and then there's close friends and contractors who are local. I assure you, I've been in real estate 30 years. My interests are aligned with yours, that my guests always have a safe and quiet stay. Accounting of human behavior is very difficult, but we do our best to manage a great stay for everyone that's safe and quiet.
Understood. I just wanted to see the process through.
Yeah, no problem. Thank you for asking.
I also think that we should note that whatever this process is for the people that are staying there, it's not the process for the public. which really their resort, where they'll go is to the police. That the police is basically, the security for the hotel.
That's not
Public end.
really accurate.
Who are they gonna call? Then they're gonna have to call the police. They can't call, I suppose they would, if they think to call management, only the
I
desk.
guess it's the same for every citizen of Hudson that runs into an emergency. They should call the police if it raises to that level.
Well, it's not sound, problems, or, whether they're, because there's noise coming in the back, in the courtyard, or, they're hearing something strange going on inside. There's nobody on the premises, so they have no choice but to call the police.
I think that there might be a way if Benjamin could address this. So if I'm a member of the public,
yep,
and I call the front desk because I'm a neighbor and I have a noise concern or a garbage complaint or whatever, that caller, I would presume, is treated with the same deference and respect that a potential paying guest would have, and that both the off-hour service that you have and the manager queue and whatnot would be able to be trained and equipped to handle that level of public concern. And that's where I think you haven't spoken to the degree to which we have staffing, remote or on premises, how that staffing is trained to facilitate the operations of the hotel vis-a-vis the general public.
Yeah. I mean, honestly, there's not a lot of interaction with the general public. We could put my phone number on the front of the building, for instance, if that would help. It just seems odd that someone would be standing in front of the building dying, can't figure it out. But yeah, we could do that, but it's no different than any other, strange incident in town that might happen. It's just not a day-to-day thing that happens if there's an emergency. When my neighbor Phil noticed that my trash cans weren't being taken, he called me. And then we called up the garbage guys and we said, we noticed, now our neighbors noticed, you guys forgot to pick up our garbage. And I'm easy to get to by phone. And every complaint has to come to me at the end of the day. That's protocol with my staff. Any complaint that a guest makes or the public makes gets brought to me. And that's the best you can do with any business, is just try and deal with things as they come, be as prepared and professional as you can be, run a professional operation with high quality people who you train. Everyone who works there is trained by my two managers, and they have to trail other people for weeks before they even think about being on their own, interacting with the public.
Okay, we're in a public hearing. Let's see if we have any other public commentary. I don't see any raised hands. No. All right, let's leave this open for now. Patrick, I know that you had some potential, I don't know, call them quite conditions yet, but some suggestions for how we might manage or mitigate the concerns.
Yeah, some considerations. Well, first, I want to address the question that came up before. I see that the planning board application says, what is the proposed use of the site? It says residential group R1 hotel. And then it says, what's the current land use of the site? Residential group R3 bed and breakfast. I was misunderstanding your question. I thought you were talking about zoning districts, which are called R1 and R3. Those are references to the New York State Building Code. So you don't need to worry about them. What you are looking at is the zoning law's definition of hotel. And based on our discussion, it might not be the definition you anticipated, but this does seem to fall under that definition. Now, in terms of a hotel that may have less staff on site than other hotels, One way to deal with a potential issue, which is lack of response if there are problems at the site, was kind of already addressed by the applicant this evening. Something that we've had projects do in similar situations is designate specific people or employees or agents who reside within the municipality or reside within X number of miles of the municipality who have to be on call, who the guests are able to get in touch with, or potentially who members of the public could try to contact in order to make sure that complaints or emergencies are addressed promptly. It sounds like we might have something in place already. And if you wanted to, you could make establishing that sort of mechanism a condition of approval. Another one is something we're discussing earlier as well. Just blanket compliance with the other code requirements. So if you are staying at this place, you could have a notification that there is a noise regulation applicable and that you are supposed to comply with it. That could just be posted within the hotel, or it could just be shared with all guests in order to try to decrease impacts that you think might occur when there aren't people on site to kind of police guests.
Can I ask a question, Larry?
Yeah.
I guess trying to clarify some confusion here. And I guess my main question is the Whaler and the Mariner. Again, my takeaway from the last meeting is they are managed differently. And again, my takeaway from last meeting was that essentially the staff at, the Whaler would be available as needed to address issues at the Mariner.
They're managing both at the same time, not to interrupt. She's checking in people live at the Whaler, and she's doing it virtually at the Mariner. She offers them.
I understand that.
Sorry.
So I understand that. So my I guess my question is, and I get it, and I appreciate you clarifying that from midnight till 7 a.m. there's no one there typically at many hotels. I guess I'm just carrying forward the notion or the concern of your neighbor that having not having a desk and not having a human body present there, as I understand it, rarely or ever, as compared to the Whaler, is a concern. So I guess my question after that prelude is, how many hours a day is there staff there, like a desk manager? I understand at the Whaler, it certainly seems on weekend nights it's till midnight. Call it 7 a.m. to midnight that they're there. You correct me if I'm wrong. And how many hours is there a live body there at the Mariner, or is your notion just to virtually manage it entirely? And by virtually managing it, meaning the staff from the Whaler would be available, obviously with some lead time to address, any perhaps potential emergency. So again, kindly answer my question on how many hours a day would a live body manager be there on site?
A manager, actually, not just.
Someone that's at the desk, like a desk clerk that would be available to handle any issues that might arise
at the Mariner.
Yeah, I don't foresee putting in like this traditional front desk there. When people are checking in, sometimes they actually come to the Whaler to check in. They want to meet Crystal in person. They've been told they can use the lobby or the back patio of the Whaler. They've been told that they can do an early drop off of their bags at the Whaler till their room's ready at the Mariner. So some people do check in the Whaler, the Mariner from the Whaler. The managers going over there, is really as needed. Anything out of the ordinary happens. Someone can't function. There's a broken coffee machine. Someone's upset with their room. There's a leak. Then a manager would run over. During the day, when rooms are made up, a manager typically will go in and just review the room. So no matter what, once a day, there's a manager who walks through the rooms that have been made and through the property. And that's it. It's as needed. It's amortizing the staff, but covering the property thoroughly. It's on camera. We see people checking in. Often Crystal's on the phone, looking at them on the camera as they walk through the front door. It's as if she's there. She's in their ear and she's watching them on the camera. They know they're being watched. They feel safe, but they don't feel intruded on. They've walked into a private house. They go to their room. They don't see anyone. They've been told to be respectful of the other guests and the community and not be a bad neighbor. And generally that's the way it goes.
Right. So I think you've answered my question. One is sort of managed virtually and one is not.
Yes. Yes. Yes.
Thank you. Thank you.
Yep.
In case of I live down here, by the way. I don't live right next to you, but I live in the lower part of Hudson. We have, and so do you, Ben, so you know that we have a lot of outages, electrical outages.
Yeah.
Seems to me more than anybody else, it seems to me. So what happens in those cases, you know, where there's some kind of a, you know, semi-emergency situation where there's no power and,
you know, short of me putting in a backup generator, which I toy with because I am a systems guy, I have 2 hot water heaters in the Mariner. I have 2 hot water heaters at the Whaler. I've got candles in every room at the Mariner. I don't have them at the Whaler because I don't want people lighting candles there. But basically, you just do your best. And we have everyone's phone numbers and email who's a present guest in what's just called, like, it's the present guest digital folder. So if she needs to email everyone or call everyone in succession, the manager can do it quickly. And it happens regularly. What goes out most often is the cable, and it's the biggest complaint. Everyone wants to work from home, do Wi-Fi, run Netflix. That is a very common thing. She has to call everyone, let them know it's not us, it's Mid Hudson Cable, blah, blah, blah. We're sorry, can we offer you a discount? And that's how it happens. It's very manual, it's very tactile. She has to call everyone.
but there's no lights or, you know, anything. Does a human show up there? I mean, you know.
Yes, I have local contractors who I use, electricians, plumbers.
No, I mean, because the lights go out in Hudson, not because there's something wrong with your building. I mean, if there's an exceptional situation, again, you've confirmed that there's very rarely a human in terms of a manager on the premises there. So if there is an exceptional situation, does a human show up, a manager type?
They should. The good news is when you guys approve me to be a hotel, I'm going to have to put in all sorts of fire and safety equipment that I don't have to do now as a legal B&B. So there'll be emergency lights, probably sprinklers. So you guys will be publicly much safer with this zone as a hotel than a B&B. And that's the good news. That's why the board should be embracing this, because there's much more control, much more code, and much more rules that govern a hotel, which I'm surprised no one's touched on tonight.
Oh, so you're gonna criticize us for not knowing what you have to do?
No, I'm not criticizing you. It just seems everyone's focusing on the negative and not the positive here. The public is safer in a hotel rather than a B&B is what I'm saying. There's code that I will happily follow. I have emergency lighting now, even though it's not the code, because it's the smart thing to do. I'm a building systems guy. I build redundant hot water heaters because of this. I have a backup cell phone for the Wi-Fi because I want it to work. That's the good news.
Okay,
Interests are aligned to protect the public, honestly.
if we don't have more questions for Benjamin and we don't have more public commentary, Patrick, do you have a resolution that you think the board can evaluate and confirm whether we want to approve this project, or what do you want to do? Patrick, you're muted.
Thank you. Yes, if you think you are ready to move forward with a potential resolution for site plan approval, I can pull up a draft, and it would include a couple of conditions that I had drafted in anticipation of this conversation. So,
Yeah, I mean, I think we've
yeah, I'm just pulling it up right now. All right. Whereas the applicant, Barlis Wedlick Architects LLC, has applied to the Hudson Planning Board for site plan approval for change of occupancy from R3 to R1. I'm going to change that to say for change of use from bed and breakfast to hotel. Good. Hotel. For property located at 26 Warren Street in the Central Commercial Zoning District, comprising tax block lot 109.35-1-20.4, the property, the application. We recite the site plan that this is shown upon, the fact that you've had this considered at application meetings on August 10th and sorry, I was not anticipating going through this application this evening, or this resolution this evening, through November 9th, 2021. A duly noticed public hearing was opened on September 23rd, and assuming you close it this evening, would be closed on November 9th, 2021. Whereas this is a type 2 action under the State Environmental Quality Review Act and doesn't require environmental review. Whereas this requires site plan approval. Whereas you've considered the criteria for site plan approval, you thereby grant site plan approval as presented on the site plan dated August 3rd, 2021, and find that the project satisfies the site plan approval criteria set forth in section 325-35H of the zoning code, subject to the following conditions. And I'm going to insert as a standard code payment, or a standard condition, payment of all fees and escrow. And second, and this is a type of condition that I've seen in other situations. The applicant shall designate a natural person or persons residing within 15 miles of the city of Hudson as its agents. Said agents must be able to respond to a complaint or emergency at the property in a timely manner. The name, address, and telephone number of said agent shall be filed with the Planning Board Secretary and the City of Hudson Department of Code Enforcement, and shall be posted within the hotel premises in a conspicuous manner. Based on the application or the applicant's discussions tonight, it sounds like they essentially have that taken care of, in that they would have a manager in their other hotel who would be responsible and would be on call. They would just have to designate them as their agent in accordance with this resolution.
Oh, Patrick, let me ask a question. You say residing within 15 miles of the city of Hudson, which, by the way, is pretty darn far for the city of Hudson. So if we do go with that, I think it should be less than 15 miles. But the reason for your putting that in there sounds like the reason why they have to be residing within a certain amount of miles is so that they can actually show up on the premises if there's a problem. And
Correct.
what the applicant is saying is that people are not going to show up at the premises if there's a problem. They'll be dealing via, be virtually or through the phone or
I
whatever.
did not say that. I'm sorry, you're mistaken. I said that people will show up, that's their job.
If there's a problem, they will show up.
Of course.
I think 15 miles is too many miles if that's really the case. And I do think that this should be in the condition.
I have a question. Are you holding me to a standard that's different than the other hotels in town?
Hey, Ben, I don't stay at hotels in town, so no.
So you're not holding me to a different standard.
No, I don't know the hotels in town. I don't stay at hotels. I have my own house.
And
Thank
I wasn't on the board when those hotels came.
Art, please. Benjamin, you are not to interject while the board is deliberating.
Thank you.
Your opinion, we will ask for it. If board members, a member of the public, including the applicant, interjects during our deliberations, please ignore them.
Thank you.
Okay, can we continue?
So what I was suggesting, Patrick, is that 15 miles.
Yes.
It, is pretty far. I mean, I don't know why you said 15 miles. Is there a legal reason for 15 miles?
There was not a specific reason for 15 miles. That was something that was developed with a comparable project that I've worked on before. However, it does sound like the applicant is going to have people just within the city of Hudson itself. However, in order to provide some level of flexibility, if someone happens to live in Greenport, not technically outside the city limits, I would recommend having a sort of buffer zone that they could be within.
I agree. I would like to see closer because that's not what the applicant initially said. So I would like to put it in writing and not 15 miles because 15 miles can take 20 to 30 minutes or longer, depending on where you're coming from. So, and the type of driver. So Hudson is what, 2.5 miles wide, long?
Yeah.
Something along those lines.
What's wrong with 2.5 miles? Is it to get the person there quickly or what?
Yeah, the conceit is that you want people to be able to respond within a certain amount of time.
Okay.
If there is some sort of issue that needs to be addressed on site.
What's wrong with
So perhaps 10 miles, perhaps 5 miles.
What's interesting about this goes back to the fundamental question this board has for this application, right? Because the applicant is proposing a largely off-premises and virtual method of addressing conditions on site. And,
Yeah, that's what I was saying. So that's why I was asking, Patrick, is your purpose here that if there's a problem, we're saying that somebody must show up? Because that's not the way they're going to be doing their business from what we understand.
It's not that someone must show up. It's in a situation like this, the board has talked about a concern about people responding to issues at the property itself, be it late at night or even just during the day. So we want to ensure that if there are issues on site that require prompt attention that could be affecting the neighborhood, that there is someone responsible who can come to the property within a certain amount of time. So we're not saying that in every given situation, they have to show up if someone calls. We just want to make sure that in an emergency, someone can go to the site.
Well,
We have a designated person.
It says complaint or emergency. So,
I can change that.
well, no, I think, I don't mind complaint. I mean, it's.
Yeah.
But I'm just saying that we're saying complaint or emergency, that there's somebody that can show up. But I don't think that this paragraph says, I don't think that it designates that somebody has to actually show up.
No, it just says they must be able to.
well, I mean, what if you just skip it entirely? I mean, you could say the applicant shall designate a natural person or persons, which I quite like. It can't be a drone or a robot, who must be able to respond to a complaint or emergency at the property in a timely manner. And, that accepts the applicant's desire to operate things remotely. We know how far the former Barlow Hotel is, the Whaler. We know that the applicant largely lives on the premises, and we know that the applicant has an after-hour service. And the critical thing for us is that there's a response, and if we're not expecting that the responder to physically go there, then eliminate completely the geographic designation.
But I
Because if it's a true emergency, then you've got the firemen and the police department, right? I mean, it's not like they have to respond within 3 minutes if there's a fire. It seems to me that the critical thing is that the agent must be able to respond to a complaint or emergency at the property in a timely manner, and that agent has to be recorded with the code enforcement officer and posted on the premises. And all we're doing is putting in writing what the applicant is saying they're willing to do already. And that the whole notion of having someone, whether they're 2 miles away or 15 miles away, you're not expecting them to hop in their car and drive there. And that
I am expecting them to hop in their car and drive there. So it's just a difference of opinion. I think that not having anybody ever show up on the premises if there's a complaint or, emergency, yes, if we're talking about a fire or, some kind of a somebody's hurting somebody, but there are other emergencies. I don't know. Whatever, guys. This is so. Then why have the paragraph at all, Larry? Because this is what the applicant says he's going to do.
Well, because
they have pictures on their phones.
there are two reasons to put it in writing. One is that it encodes that it has to happen, and two, that there is a mechanism by which the City of Hudson Department of Code Enforcement knows who that person is and can also contact that person. Right? It puts it in writing. And as we've seen lots of times when the applicant says something, when it comes time to this very moment and we put it in writing, they resist. And it seems like, the critical thing is that there is a designated person. That person is committed to responding in a timely manner, and that the name of that person has to be part of the public records. The public knows who the designated person who's going to be responding actually is. And
that person could be a service that is located in Missouri. So
Yeah, no, I know, and that's what's being proposed here. The reality is that's the proposal, and that the owner does have an apartment or a dwelling inside the building, so the owner will be there at times. The managers at the Whaler are local. We know that they are. Those names would have to be with the code enforcement officer, and the expectation is that between them they're going to cover whatever the issue is. I'm not saying I like it. I'm not saying how I'm going to vote on this, but I'm saying that the wording simply nails down what the applicant actually is. My understanding of what the applicant is actually suggesting that they're going to do.
But we can also suggest other ways. For example, that somebody has to show up if there's a complaint.
Right. No, we could.
I want to make a quick comment. And this is sort of stepping back a bit. I think there's a fundamental difference between a space that's occupied by people vacationing, sleeping, residing, short-term hotel occupants that has a consistent and known human presence and one that doesn't. And I guess I was just thinking this isn't a perfect analogy, but teenagers in the basement, not that there's gonna be teenagers, but adult in a basement with a human upstairs feels, acts, and is managed differently than those same people in that space with some cameras and phone numbers to call. And I think that this is sort of, a little bit of this stepchild of the Whaler and is not managed comparably and is a new hotel that's largely unstaffed in a residential neighborhood. That's my concern. And I don't think whatever this wording is, and I get it, we're trying to come up with some wording that meets the applicant's desires, but that's my fundamental concern. And I would say that that's the fundamental concern of the neighbors.
So is there a wording, Clark, that you can suggest that will allow you to support the applicant?
Not at this time. barring the whaler being, the Mariner being managed comparably in terms of staffing as the, clearly the applicant has, the owner, Ben, has purchased the whaler. Good on you, you've done a great job, beautiful building, and is managed per your business plan with staff. And this one, per your business plan, is managed without staff, regularly on site. So I don't know how my concerns are allayed unless the Mariner is not the stepchild, but another lovely building that's a hotel that is managed and operated comparably. So, I mean, just in terms of our steps here, if you want to come up with some language that meets the applicant's desires, feel free. I don't support it. I'm just one voice here, of course, but that's my big concern.
John, what do you say?
I'm kind of waffling on this. I excuse me. I agree that, within a certain number of miles, that's kind of a nebulous thing. We do say that they must respond at the property in a timely manner. Again, comes down to what's realistic there. I kind of don't have a problem with this. And to have somebody who resides within a certain distance who can get there at a reasonable time. I guess I don't have too much of a problem with it. The one question that arose to me is, I'm assuming that since it's a B&B, there won't be phones in every room. I think maybe having a central telephone there somewhere so that people can get in touch with somebody might be a good idea. But overall, I don't have too much of a problem with it.
It's not a B&B, John, it's a hotel. But
Oh, no, I understand that, Laura, but I'm that's, and what my point is that even if it is a hotel, since I don't imagine that they'll pay for however many phones they need for however many rooms, that, there are people who don't use cell phones. So to have a phone there for people to access the staff would be a good thing.
Like a house phone.
That's a good
Right,
idea.
exactly, right.
Talking about landline, right, John? You're talking
Right.
about landline.
Right.
That's a good idea.
Teresa, what do you say? Teresa? You're muted.
What do I say?
Yep.
You want to come back to me?
Okay. Gene?
Okay, I don't have a problem with this paragraph here. The applicants already said what is mostly in this paragraph, that employees will respond in a timely manner. And employees are going to be there at different times of the day or night. The restriction about residing within 15 miles, I don't see the need for that, but I don't have a problem with that either. So I like this paragraph.
Laura?
I'm in agreement with Clark, though I do think that if this is going to be approved, then I think John's idea of a landline in the common area is a very good one. Just because of outages and issues. and the fact that there's, that there's no security here.
I dropped my phone in the river, my charger broke. Yeah, I could see that. Teresa, what do you say?
As far as this paragraph is, I think we should be direct in what we are asking for. If we're asking for somebody to come within a reasonable amount of time, I think we should kind of say what that reason is, because my reasonable amount of time is not the same as yours. And if I'm working and I'm busy, then my reasonable amount of time definitely won't be the same. As far as the number of miles, I don't know about that, but he did say that the applicant did say that there would be people at his other hotel.
Yeah.
So maybe make it within that range. This is a hard situation for me to get by, because it's the first that's ever come upon this board. I'm not saying that there's others that should have came when I wasn't on the board, but it's just, this is a residential house. And now we're talking about giving him approval to become a hotel with no staffing. I mean, anything could happen. Fights. I mean, nobody's talking about fights. People fight. People, talk loud. They have, disagreements. Everybody, all kinds. I do agree with John. If you're going to do something, do put a landline, but maybe not a landline, but one of those phones where you pick up and you get the emergency person right away. They can't dial out. Just pick up the phone, just have several of them where they can actually pick up the phone and somebody's on the other end and they can say, look, we have a problem here. We need somebody here.
What if it doesn't say residing? Because, the proposal is not about them residing, right? I mean, the applicant shall designate a natural person or person residing or actively employed within 15 miles of the city of Hudson, right? I mean, so that that the person is nearby, whether they're at the Whaler or in their home or out to dinner or whatever, they're nearby. And because frankly, people can live wherever they want to live, and if they look, my trainer at the gym lives in Great Barrington, Mass, and drives 45 minutes, right? Like people have different kinds of lives, and I think I don't want to get stuck up on where they have to reside. That seems frankly irrelevant to the nature of contemporary commuting. But I do understand the board's concern that someone be available, and the notion that the staff and the management at the Whaler are available. Maybe it says something like the applicant shall designate a natural person or persons available to be contacted within 5 miles, right, of the premises, not of the city of Hudson. But that there is someone nearby on call, and maybe we do that during a set number of hours so that we can acknowledge that there's a service for the off hours.
You can't do that though with emergencies, Larry. They happen whenever. So my feeling anyway, didn't mean to interrupt. But.
Yeah, no, I hear you. But I've been in lots of hotels where, after 11 p.m. there's not a person at the front desk, right? You have a key card, you swipe, and if there's something comes up, you call the service, right? That's quite common in hotels. I mean, I wouldn't expect that the person is within 5 miles or 2.5 or 12, 24 hours a day. That's just not how the world works right now.
Yes, I'm curious, Larry, when you say, let's just say, when you say within 5 miles, again, once they say, we say anything that like residing within 5 miles, means that they have to be able to get there. There's nothing in this paragraph that says they have to be within a certain amount of miles and then show up. the miles doesn't matter unless we're saying they have to come to the premises if there's a problem.
Right, that's what I'm saying. You know, change that to saying to persons residing and or actively available within 5 miles, right? The critical thing is that they're nearby.
Right, so then the next sentence needs to say something like, said agents must be able to come to the premises, to the hotel premises or something, you know. Otherwise, I don't understand why we're even saying within a certain amount of miles.
Right.
What are we trying? Are we really, what we don't want is residents of the hotel at the time or neighbors calling the police for something that the management of this hotel could have taken care of, right?
Exactly. We don't want to switch onto the public realm the responsibility of the management of private enterprise. I totally get it.
We don't, and we don't want to set a trend for that either. So we have to, maybe we should think about this because we got a lot of things to do.
Is there a way to word what we're kind of all in a convoluted way saying, including John's idea for, I mean, I do think a landline is in any aspect is a good idea. And I mean, a landline, I have to distinguish that because I have a landline that is still run by a cell service. So I mean, a landline that's not run by the cell service, I think is what John meant. I mean, but
look, it's 9 o'clock. We're on our second item on the agenda.
And that's what I'm going to bet on y'all.
Yeah, this is insane. So it seems to me, Patrick, you've heard the board's concerns. I don't, we're going to resolve this with wording that is going to get a majority of votes in tonight's session. And I think that perhaps you can craft language, perhaps it's language that you need to, consult with the applicant to do. And we can either pick this up yet again on our special session, or if that's already now overloaded, we place it on the agenda for next month. I mean, my goal here is to get language that satisfies the board's concerns. And we need 4 votes. And I just looking at the thing here, I don't see us getting 3. So, I mean, if the applicant wants us to push it through to a vote tonight, we could. I think it might be useful for you, Patrick, to be able to come to some kind of language that you can run by the board and that we can take up at a subsequent meeting.
And if we're going to do it on the 18th, then again, Patrick, I hate to do this to you, but if we could have it beforehand, just so we can look at it.
Well, to address that point, if the planning board is going to adjourn its discussion of this, or is it going to be until the 18th or until the regular meeting?
May I suggest next month?
I agree with that because I know we're having these special sessions, but what's happening by default is we have 2 meetings a month. And I know we have 2 meetings a month, but we can either declare that we're officially having 2 meetings a month or continue or,
we have a full
meeting a month and special sessions as needed.
Right. I mean, look, I'm happy to ask the applicant. I think the reality is it's not there's too much to do between now and the 18th for us to take up this matter on the 18th. If the applicant wishes us to take a vote, which I would highly discourage him from asking us to do, we can do it tonight. Otherwise, I think we pick it up. We allow our lawyer to craft the appropriate language. We pick it up at next month's standing meeting, and at least at that vote, we'll have 7 bodies in the room, and we can see how this comes out.
Okay.
Yeah.
Yeah.
Thank you.
Of course. Thank you for your time. I really appreciate it.
Thank you, Benjamin.
So Ben, you want us to take us up next month, correct?
Yeah, let Patrick work on some language that we can all, feel good about, and let's go from there.
Awesome. Thank you.
Thank you, guys. I appreciate it.
So we're going to leave the public hearing open, right, Patrick?
Yes, I'd say leave it open.
Okay. Thank you
Can I
very
get
much. Patrick, thank you for your yeoman service. I believe that you have the rest of your evening ahead of you. We are still enmeshed in this board. We have
Best of luck,
public. What?
Oh, sorry, I was gonna say best of luck, but before I go, can we get a motion to continue the public hearing?
Yes.
So moved. Laura's moving and who's seconding? You can't second, Benjamin.
I second,
Oh, he's saying goodbye. I thought-
Bye-bye. Thank you, Laura.
I second the motion to, what?
Okay.
Continue the public hearing.
Board.
Continue the public hearing.
Oh, all in favor?
Aye.
Aye. All opposed? Okay, we have gotten through 2 of 3 public hearings. Board, we need a break, but I would suggest that we might go through
The
our
public
next
hearing.
public hearing, which I believe should be straightforward.
Mhm.
That public hearing, and thank you applicant for allowing us to juggle, excuse me, it's late, the public hearing roster for tonight. So this one is a public hearing for 110 South Front Street, which is a site plan and special use permit application from Basilica Hudson, proposing that a portion of their existing building be converted to an art gallery. The property is in the RSC zoning district, and an art gallery is a conditional permitted use with the approval of the planning board. Board, you may recall that last month we had the applicant present to us based on the nuances of the code. We were not allowed to take action on that application absent a public hearing. So we needed to schedule a public hearing. That's happening tonight. For that to happen successfully, we need the applicant to make what I hope is a concise summary of the project for the public, and then we'll see how it goes. Do I have a motion to open the public hearing?
I move.
I'll second.
Wait, we don't have a lawyer on this one, so I have my little piece of paper. Hold on one second. I've got a pen. Okay. I'm actually ready for this. Okay. Okay. So Laura,
Excuse me. I'm sorry.
you made the motion, and who seconded it?
I did.
John.
Okay. Thank you. Okay, applicant. And as brief a way as possible.
For sure. Good evening. Thanks so much for taking a look at this. So I'm David Slaza. I'm the designer and owner's rep on this project and project manager. Is it okay if I share my screen just to step you through some details? Okay. Okay. Can you see that? Okay. So what we're talking about tonight is reuse for the Basilica Hudson owns several buildings on a larger piece of property down on South Front Street. We're talking about this. Can you see my cursor or no?
Yes.
Great. So this smaller building here, which is known as the back gallery, it has been for a number of years, and the front portion of it's been occupied by Kite's Nest, another nonprofit, also for a number of years. I'll just step through a couple photos. That's the way the building looks today on the front. We are not talking about the big building at Basilica at this time, although that we will come to you with that at a later date. This is the facing the building that would be toward the large building, right? So that's essentially the south side of the building. I'm sorry, that's the north side of the building. That's facing up toward Amtrak and that way, and Kitty's in that direction. This is the opposite side. So this is facing the big building. And this is the rear of the building. As you can see, it's in rough shape. The roof leaks. There's a number of kind of issues to it. Our plans include shoring up the building, insulating the building, and changing egress a little bit to get in and out in smarter ways. If you look back, there's a couple of big doors here that we're going to close in. I can show you that here. So this is the proposed plan of the building that would, so again, this is the front face that you normally see as you drive onto the property. Nothing here would change at all. We would be changing some of the back side of the building, applying additional envelope around it, basically. So adding to the concrete block wall insulation and an exterior cladding of shiplap vertical pine. We would add, we're proposing to add these new double doors on the side here, where the previously it was this painted block wall. So we'd be opening up this block wall here. The propane tanks would be going away, because also part of this project is all the buildings are moving toward net zero. So we're going carbon neutral on the site, which includes eliminating all burning of fossil fuels and such. So that's part of it. So new doors there, and we close in all those kind of crazy, big, bad back doors and keep the person door in the back that exists. The elevations from the front would be completely unchanged. This is looking at that, what is that concrete, the mural wall we call it now. So this would be where the new doors are going in. The reverse side would be completely unchanged, and the back would be closed up. That's where the big kind of rickety old doors are right now. So we'd close that all in. I'll just add that this is part of a bigger renovation of the total grounds and campus that we're imagining. And this is something that we're not talking about in this particular proposal. What we're just talking about is, and Larry, help me on this, because I don't understand all the nuances of it, but somewhere in some paperwork, this is listed as a workshop or a storage building, I guess. And so we are writing that use on paper to art gallery, which is, what it has commonly been used as for a number of years. So that's what's up here. And I'd be happy to answer any questions.
Board, do you have any questions for David before we open it up to the public?
No.
Okay, David, why don't you stop your screen share and we'll see what the public has to say. Any hands? Does anyone see any hands? Okay, well, I think that we can close the public hearing and move to.
Wasn't it a hand up with Doug?
I didn't see Doug.
Oh, I thought he had his hand up, sorry.
I only have one page of whatever it's called, participants, and none of them seem to be indicating they wish to speak.
Do you see a Doug, Teresa?
Yeah, there's a Doug over here.
The architect, yeah.
Oh, that's Doug. I see.
Okay, then do I have a motion to close the public hearing?
So moved.
Second.
James seconded.
Okay, I'm gonna, I hope I can do this right. Okay, there's my document. I'll do a little screen share.
It's easy for you to say.
Do it, Larry.
There you go.
There you go.
Okay, can you all see the document on your screens?
Yes.
All right, I'll read it to us. City of Hudson Planning Board dated November 9, 2021, resolution for conditional use permit approval for Basilica Hudson at 110 South Front Street. Whereas the applicant, Basilica Hudson, has applied to the Hudson Planning Board, HPB, for a conditional use permit for the project located at 110 South Front Street in the GCT zoning district, comprising tax block lot 109.11-1-20 and 109.11-1-42, the property application. And whereas the HPB considered the application at its meetings on October 14th and November 9th, 2021, and that is erroneous. What's going on there? I have a random dash. Whereas a duly noticed public hearing was held on November 9th, 2021, during which all who wish to speak were heard, and whereas the project is a type 2 action pursuant to the State Environmental Quality Review Act, SECRA, and whereas the project requires HPB approval pursuant to 325-34 of the City Code, Whereas the HPB has reviewed the criteria for a conditional use permit set forth in 325-34, and now, therefore, be it resolved that the HPB hereby grants conditional use permit approval as presented on the site plan prepared by Wallace Architecture and dated August 17th, 2021, and finds that the project satisfies the conditional use criteria set forth in section 325-34. Now, board, if there are conditions that we wish to apply to the project, whether that's about noise, lighting, what have you, now is our time to review those things or discuss those things. We actually haven't talked about a lighting plan and whether there is any proposed evening events, receptions. I don't know. David, do you want to speak to any of those issues?
Yeah, as the building's currently used, it is not a place for evening events. The big building is for sure, right? And the big building has a different set of circumstances, but this one, not so much. And frankly, it hasn't been used so much because it's in such bad condition. So that may change. There will be a lighting overlay to this as well. It is our intention to add exterior lighting to the new entrances. There is some lighting on the front of the building now that we maintain and keep up. Noise in this building is not at all a plan in the program. The music events and things are all inside the big building.
Or do you have any stipulations or conditions that you want to propose to this resolution?
So I just want to say that I used to work down in that area, and I don't know if it was this particular building. I have been to art shows in this particular building, but I think it was this building, because I don't know that there's another one where I think that the space was rented to some live music, and it wasn't outside, it was inside. And I have to say, the whole neighborhood was not pleased. It was because, it reverberates up the hill there. So I guess I hadn't thought about that. I mean, if the plant, you hear art gallery, so you think art gallery. So, rather than, live bands in the future, where there's not much insulation. Is this place going to be insulated in some way? And
yeah, it is insulated. It's part of the proposal. I mean, that is interesting though. I have a friend who's a curator of sound art. Does the gallery, will it have hours of operation?
I'm not so much involved with the programming plan in terms of how they're going to use this building. My understanding so far is that it's mainly used as a residency center right now. So it's used for artists to come in and make work and exhibit work on a kind of rotating basis. And it's all been visual art that's not sound-based or in any way like that. There's been a painter in the space as long as I've known it. So that's my understanding of how the use is going to go. I think that the sound, Laura, that you probably heard is more from the big building. I mean, there are
no, David, it really wasn't.
Okay.
I mean, I had to walk down there. I didn't walk. I drove down there because I could not believe how loud it was, and it wasn't the big building. It was just. Then that's the only other small. I think it was rented to these people or something. But eventually, actually, somebody in the neighborhood called the police because the police had to come. It was really, really, really loud. It was bad. But I'm not concerned about that. So hey, Larry,
yeah,
I don't. Since we don't get hard copies anymore, can you look at the application itself? It might talk about hours.
Well, didn't you say there was noise or something? You live down there?
No, what I was saying was from the bigger building.
But
and they usually bring it inside by 10 o'clock, but sometimes even inside it can get kind of loud.
Well, my question is, by approving, are we giving them a platinum card to do whatever they please with this building? It's not saying anything to be used for an art gallery.
Well, we'd have to check the code to see what the code, I don't know. I don't know. And then once again, we have the lawyer on, with us.
Well, we went through the noise part of the code a while ago, and if that's a concern, I think that is pretty applicable here.
Yeah, I mean, we have an opportunity to put conditions. Obviously, there's some that's needed.
It might be in the application itself. I was just wondering if we could actually.
I'm going to stop the share of the resolution and
Okay.
start the share
The application.
of the application.
And David, while we're looking at this, maybe you can eventually speak a little bit more about the lighting, because I mean, whatever you're going to do, we're only concerned right now about this building. So is it in your drawings what you're going to do with the lighting? And if it's not, then you need to explain it and we can make it a condition. The outdoor lighting.
Yeah, so there's existing lighting on the front of the building and that will be maintained. And there's plans to have lighting near the doors on the new doors that will go in on the side of the building.
Just so that you can actually see yourself get it going in and out. I mean, yeah. So
Definitely.
maybe we write a little bit of something about that, since unless it's in your plans already.
That level of detail is not in these plans right now.
We'll write it up.
So
I'm not saying anything.
yeah, there's not much
Is
detail.
this
in this.
application complete? Is this a complete application?
Yes.
Oh. Blank spots.
Can we just ask one more time what the questions are that we're searching for answers for here?
Time of operation, is one of them.
Yeah.
The building is
Loud
currently,
music.
the building's currently used 9 to 5, and that is my understanding of the plan going forward.
Will the building be rented out for, like it's an art gallery? So that's a nice, beautiful, clear space once you fix it up.
Yeah,
We're not talking about for now. We're talking about once you put your money in that building, is going to be a nice place, I presume. So my issue is now it becomes a building of interest for weddings, parties. I mean, an art gallery can be used for a party, so are we giving you a platinum card to take this beautiful art gallery and do what you like? Because I don't see any type of
Well, even if it's not used for an event space, I mean, I've been to a lot of art shows that have.
Yes, you're right.
Well, I mean, they have music, ambient sounds, drones. I mean, there's
people. Yeah.
there's lots of things that might wind up being a nuisance. And of course, again, we have our noise ordinance.
yeah. We're not proposing anything that's not allowed by code and that's not, part of what's already going on in the building, or that has historically been happening in the building. It's not a change of use. It is a clarification of what's happening. But I hear what you're saying, and yeah, it will be nicer, and we do hope it'll be used more. Right now, it's barely used. You know what I mean? Like it's so we want to be able to use it more than barely.
It looks
but
like it's
that's-
leaning now. Looks like it leans.
Yeah, we want to make it right. We're not trying to make it into.
Look, just so we're clear, I don't think that the board's comments here are in any way predicated on, coming up with some reason to stymie the plan. I think we'd rather have the building improved than not. And you're representing a property owner, and we like when property owners, improve their premises. I think that there's a concern that's probably a genuine concern that we may not have as strong an understanding of
The uses.
be approving, right? That this could be an open-ended approval, given the fact that art itself is by its very nature an open-ended enterprise. We could be inviting a whole series of sound and light based work that could have an impact on the surroundings in a way that I hadn't really thought about before we actually got into the public hearing. And I think I'm trying to find here, we just had, sample language from a previous resolution about, the applicant will abide by all relevant provisions of the City of Hudson code concerning light and noise. I can imagine something like that might be useful as a stipulation. Whether we need to go beyond that, I don't really know how the board feels.
I'm not sure either. I think the only thing is that since David didn't really, detail the lighting, and what he's talking about is very simple, but it's not in his drawings, that we put a little quickie condition that confirms what he verbally has said. The lighting's going to be on the outside, and then I don't know what to say about the noise issue in case there's a big event. Well, look, I think when that noise issue happened when I was down there, there was if the building's bad now, it was worse then. And even though I did see a cool art show in that building, and it's actually a nice size building. It's a good size. You can get a lot of people in there. That's a little worrisome for if it's going to be a big band, but the building was in bad condition. I think they had the doors open. We can't predict, the building's going to be better. And hopefully we don't have those issues. I don't know what to do, guys.
No, I think we have to do a quick sentence here. We don't have a lawyer with us. We have a lawyer drafted on the spot, but I would say let's go back to the screen share. Resolution. Are we back there?
Yeah.
The applicant agrees to abide by all relevant City of Hudson code provisions concerning noise and exterior light. Anything? What do we say about that? Anything else you want to add? Is that?
That seems pretty good. You have a little extra something there, Larry?
Do I have a little extra something? It's it's 9:22. I got nothing extra.
Oh, no, a little L. Oh, I see. Okay, yeah.
Yeah, I had a little bracket, a little.
Okay.
There. Oh, you have any bigger? I can be bigger.
Do we have any time in there? No, we're not going to do that.
You think hours of operation?
Yeah, hours. That's
Noise, hours of operation, and exterior lighting.
Noise.
Well,
hours of.
And anything else we didn't think of? I'm just kidding. I have no lawyer. I'm just kidding, guys. Okay, that sounds good.
Okay. Anything else? I mean, I think that, look, we know the operation here. I think we understand it. I think we need to make sure that we're not putting a burden on the neighbors. I think we're fine here, unless folks have
Yeah.
something to add.
Larry, on the City of Hudson code provisions concerning noise, hours of operation, and exterior lighting. Hours of operation should not be in there. That should be a separate sentence. We're looking for the hours of operation, but the city doesn't control it.
Right.
You know what I mean? So it should be a second request or second condition that they make available to us what hours they're gonna be working, what days are they gonna be working.
But that's,
It's true. Then they have to come back, right?
yeah, and they have to come back.
You know, we don't know what the hours of operation are gonna be. Is it a
You're right.
24-hour operation? The applicant here said that it's commonly 9 to 5.
Comment.
But is that gonna be the mainstay? Is it gonna be 9 to 5, Monday to Friday, weekends? Is it gonna be later than that?
Well, you know, David, can you speak to the owners? I mean, you know, speak for the owners. I mean, you know, could we say something? Hours of operations, including associated events, will not, what's the, well, I forget the wording, but, you know, will not happen after 10 p.m. Sunday to Thursday and an 11 p.m. Saturday, Friday and Saturday.
That's for outdoor stuff, Larry, that.
Jean is speaking. What'd you say,
Regular
Jean?
business hours.
Okay.
Right, but they may, you know, if there's an art opening and it's an evening event, maybe associated with Basilica, you know, you can imagine something going till 11. It's not, you know, it's not onerous. It's people looking at art and hanging out and drinking wine and whatever. So I worry about too much burden as well.
We can't regulate how long a building business stays open on the inside, can we? They can stay open as long as they want. I guess unless there's alcohol involved or something. But you can have.
Wait a minute. We just did that with a whole bunch of businesses.
Yeah, but that was for outdoor activities.
I'm talking about indoor activities.
Yeah, that's true. We don't regulate what happens inside. So we could say exterior outdoor events associated with the use shall not exceed 10 p.m. Sunday to Thursday and 11 p.m. Friday to Saturday, which is just that's what the code says, right? But we did address that by this thing, right? Because that is the provisions concerning code noise.
No.
But Jean, when you say hours of operation, you think that we should, on the inside, on the interior, that we should be designating what the hours of operations are for the interior of the building?
On all of the applications that I've seen since I've been here, there's always hours of operation listed in the application.
Yes.
This application doesn't give anything of the sort. It doesn't tell you when it's going to be open. Do we
So
need
maybe
to have?
it's incomplete. Is it incomplete?
Well, it's not incomplete because it's actually not one of the questions on there. It's not one of the questions on the application itself. So it's not an incomplete application. It's just that it's lack of information. Do we need to have it? No. If, can David clarify the hours of operation? Or is that too late now for him?
Yeah, the normal hours of business are 9 to 5. There will likely, as I think Clark mentioned and others have acknowledged, there will likely be events that go into the evening. Those would be indoors. The concept here is not for outdoor events. And certainly anything that will be happening in and around the building would be mindful of the code.
Okay.
So if we said applicant agrees to abide by all relevant City of Hudson code provisions concerning exterior noise and exterior lighting, would that
An exterior operations?
No, you don't want to say exterior noise because
No.
there could, I mean, look, I have been in galleries where I walked in and I walked out again because the whole goddamn thing was about screeching and you know, dissonance, right? I mean, like that happens in art.
Okay, all right. His answer is satisfactory.
So we don't have to put anything about hours of operation, you don't think?
No, no, no. He explained it, okay, thoroughly.
Okay.
Yay.
Okay, so we're good to call a vote? Do I have a motion?
So moved.
Got it.
Was that you that seconded?
Sure.
Yeah, okay, great. All in favor?
Aye.
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 All opposed? Okay, I'm in favor. Okay, so we have approval.
Finally.
All
Yay.
right. It is 9:30.
Thank you.
Thank you, David. Did we close the public hearing, folks?
I don't know. Let's close it. So moved.
Yes, we did because we, resolution. All right, so let's take 8 minutes. Shall we do that? And break. All right, I'll stop the share on the resolution and we will reconvene at 9:38.
9:38. Okay, thank you.
Thank you all so much. I appreciate your support.
Thanks. Is Jean back? No, Jean's not back. Okay, so we're missing Jean still. Um, let's just wait a minute or so more for Jean. 1, 2, 3. We are a quorum. Let's give him another minute. Okay, Jean's back. Welcome back, everybody. If we still have folks in attendance, God bless you. We have a couple of matters of old business. I hope that they will, no, one matter of old business. I hope that we can move efficiently. We have before us 16, 18, and 20 North 2nd Street, which is an application for lot line adjustments between 16 and 18 North 2nd Street and between 18 and 20 North 2nd Street. The lot line adjustments would allow for the construction of 3 new 2-story single-family detached residential buildings, 2 accessory buildings, and 3 shared easement parking spaces. So board, just to remind you, this is the Digifab application. We saw them a couple of months ago. They have that cute little historic building on 2nd Street and the vacant lot next door. The cute little building apparently is too far gone to salvage. They're proposing tearing it down, reapportioning the lot lines across the parcels. We sent them based on our legal counsel over to the ZBA. The ZBA held a public hearing and approved the project, and it is now back before us. The ZBA is the lead agency on the project. So our goal here is to refresh our familiarity with the project, and then if we're able to do so, to move towards a resolution to adopt, a draft of which I have for us tonight. Okay, Jennifer, are you speaking for the applicant?
I am.
Okay, did I get anything off on that summary, or is that pretty much as you understand it?
I think that is everything how it aligns with our understanding as well. We did get approvals from ZBA for all of the zoning variances. So at this point, we are looking for approvals on the property line adjustments.
Great. Okay, so why don't you just briefly show us again what your proposal is so that those board members can remember where you are.
Absolutely. So I assume everyone sees my screen.
Yep.
So this diagram illustrates the existing lot plan. So we have 20, 18, and 16 North 2nd Street. Lots 20 and 16 are quite narrow, and they're also quite short. And our proposal is to essentially give some of the property from 18 over to properties 20 and 16. So this is the proposed lot plan diagram, and it allows us to build 3 single-family detached units so 1 on each property, and the 2 longer properties would potentially have an accessory building at the rear. And each property would also have its own dedicated parking space, which would all be accessible via a shared easement. And then the actual survey plan that Crawford put together for us is indicating the same thing that the diagrams do as well.
Okay. Or do we have any comments or questions for Jennifer? No.
Wait, I have one. I
Okay.
just wanted to know get out of here. The shaded house. Yes, that's the existing property now, right?
That's the existing building on,
gonna
on
tear
lot
that
20.
down?
Yes,
Okay, that's my question.
yes, it's in disrepair and it's
No, I'm happy to
yeah.
see that someone finally bought that and is doing something with it. Thank you.
Yes, but
I
it's so
applaud you for that.
So sweet to restore that thing, but okay. We're not in the historic district. Okay.
It costs more to restore it.
Do we have any questions or comments for Jennifer? No, I already asked that question. Are we ready to proceed to looking at a resolution and possible wording on this?
Yes.
Okay. Jennifer, then why don't you stop your share screen?
Will do.
I'll start my share screen. Let me see. Queued these things up, I hope properly. Okay, I need to hit the share screen button. Okay, so this is the City of Hudson Planning Board resolution for site plan approval for digital fabrication workshop for lot line adjustments at 161820 North 2nd Street. Whereas the applicant Digital Fabrication Workshop has applied to the Hudson Planning Board HPB for site plan approval for lot line adjustments at 16, 18, and 20 North 2nd Street. Tax lots 109.43-02-18, 109.43-02-19, 109.43-02-20. The property is located in the R4 zoning district, and whereas section 30, this is important for us, guys. Sorry to editorialize. Whereas section 325-35.1B2 of the City of Hudson Code provides for the HPB to classify the subdivision as either major or minor. Pursuant to section 325-42, minor subdivisions are any that create not more than 2 lots, and therefore this is a minor subdivision, only requires site plan approval. That basically means that we are allowed in this case to waive the public hearing. And whereas pursuant to 325-35H3A, the HPB has determined to waive the public hearing on this site plan application. And whereas the application for a lot line adjustment is a type 2 action under seeker and no further action is required. And whereas the HPB has reviewed the criteria for site plan approval set forth in 325-35. And now therefore be it resolved that the HPB hereby grants site plan approval for the lot line adjustment as presented on the survey prepared by Matthew J. Bowe, PLS, dated October 20th, 2021, and finds that the project satisfies the site plan approval criteria set forth in section 325-35H of the zoning code. Do we have anyone who wishes to move to adopt this resolution?
So moved.
Clark, second.
I'll second.
JC, do we have any discussion about the language, the wording, or the implications of this thing? I think the critical thing here is this paragraph, which ideally we're going to see again shortly. Because it's a minor subdivision, we don't need to have a public hearing, which pleases me to no end. Are we ready to vote?
Sure.
Hey, all in favor?
Aye.
Aye.
All opposed? Okay, we are unanimous. Jennifer, congratulations.
Thank you all.
I'm getting an email follow-up from Steve, our chair.
Sounds great.
Great, thank you.
Thank you. Have a good night.
Thank you. Okay, board, that was great. Thank you. Hey, next. We have 3 items of new business.
Larry,
Yes.
the only thing is I didn't prepare that. I think that was a Crawford survey. That was not mine.
Oh, dear. Oh, dear. That's a copy paste error. Okay. Thank you
Good.
very, very much. I think I got the date right, but and I'm glad that you're in our meeting, actually, so that I can fix that. Board, do we need to re-vote, or are we fine with the editorial, the edits I just made?
Good.
Okay.
That's just a typo. It's not.
Yeah, no, I understand. Thank you, though, Matthew, for pointing that out to us.
Yep.
All right, our next item of business is we have 3 items of new business, one of which we may move forward, but our first item of new business is for 60 South Front Street, which is a site plan application from the owner. The applicant has submitted a proposed change to their existing site plan approval dated 7/14/20. The change is to eliminate one of the 2 approved retail stores. As per section 325-35B of the City of Hudson Code, any change or amendment to an existing approval may reapply for a new approval. So I think, board, this is the pole barn next to Kitty's. We previously approved this project, and the applicant now wishes to reallocate the retail space from 2 to 1. I think there also may be some signage issues involved as well, and a slight change in the openings. I think what we might do is let the applicant actually refresh our memory on this project, and then we can begin our discussion.
Hi, well, I'm Ben Fain. It's nice to be back.
Ben, welcome, and I'm sorry that we're making you wait till 9:51.
Oh, that's totally fine. It's you're saving the best for last, so it's okay. Well, we're here to make request a couple changes to our site plan. We think they'll make a better building. I'm here with the dream team, really, Matt Grubar, project manager, and Ted Kane, our architect, and Jason Wyckoff, our builder. So if you have any questions at all, we're all here to answer. But I think I'll let Ted take the lead. Ted, if you want to take it away.
Sure, yeah, so I'll share my screen.
Sure.
Okay. Yeah, so I thought I'd just give a update or a refresh of where we're at. So this is actually the site plan that was approved previously. We're across from the Hudson Station. This is 60 South Front Street. So I'm the architect working on what we're calling the Red Barn, which is the pole barn you mentioned. Also on the site is Kitty's to the north. So we're not presenting anything related to that. So it's just about the building that is we're needing to rebuild it. So as we presented last time, we're building a new foundation. So we've actually salvaged the wood and we'll be reframing. So as we submit to the city, there were some changes, just part of the programming change, as well as the entries that we're going to present today. Let me present full screen. Yeah, so this is the updated site plan. So I wanted to go through some changes that occurred. So in the original plan, we had a wine shop at the north of the site. So just to orient you, the north is to the left. This is Kitty's at the corner, and then the barn here further to the south. So one of the changes that occurred is that the wine shop originally was entering from the north of the building. In review with the liquor authority and the applications for the wine license, they did request or require that it's actually entering off of Front Street. So that was one of the changes that we're making the entryway instead of to the north, now to the west to the Front Street orientation. The other change that happened just in the programming is we needed an additional space for our kitchen. There is an addition to the building in the back. And we treat it in a way as kind of like an outbuilding so that the strength of the barn is maintained. And this is a kitchen that's actually within the garden. So the idea also that, the cook is visible and it's kind of part of the back garden space. The other change on the site plan to the south, there was 2 ADA spaces previously. So we consolidate to 1. We reduced the curb cut from original 27 feet down to 16 feet now. Zooming in a little bit, you see the kind of footprint to the building. So the entryway at the north got switched to this side. So we did have some changes just at the entry sequence. And I'm going to show renderings of previous versus new, just so you can see it 3-dimensionally. But just to orient the plan, this is the entry to the wine shop. There is a ramp that goes up to Kitty's. We're providing the ADA access from this ramp here, as well as steps. So that's the new Kitty's accessible entrance off of this platform. There is a ramp as well, which we're integrating into the landscape. So it's not really a ramp in that it's 1 to 20. So at 1 to 20, it's a very gradual slope that doesn't require handrails or guardrails and so forth. So it helps us to kind of integrate that into the overall landscape. The entry to the event space is here. So one of the changes that occurred is we no longer have a maker space that we were calling it before. There used to be a secondary commercial space off the entrance to the wine shop at the north. So when that was eliminated, it allowed us to kind of shift the program a little bit. So now the entryway got shifted about 15 feet to the north. So otherwise the same. So the idea being that you enter into the relative center of the space and you go to the south into the event space. And then the north is more function for the kitchen and the bathrooms. And then the wine shop is a separate entry from the event space.
Just remind me, did we have a kitchen?
We did have a kitchen before, so the kitchen was this footprint. We just additional bump out here. We needed additional, also the cooking equipment required more space, and rather than have things popping out of the barn, we just wanted to kind of integrate all of that cooking function into one space. It also allows us to connect. There is a kitchen at Kitty's, so people could, it just allows them to use both facilities.
I don't remember.
The bump out is the bump out kitchen is a new build, right?
Yeah, it's actually all going to be rebuilt. So we're rebuilding the foundation and using the original wood, but it's going to be restructured. The original structure did not have any insulation, and the foundation was basically piles that had kind of fallen apart. So we're rebuilding the foundation.
I meant that the kitchen is a new NEW build, or was that already there?
No, that's new. So that's an addition to the original footprint of the barn.
Okay. And the kitchen will service the event space, is that?
Yes, so that's kitchen for the event space.
Got it.
Yeah. Just zooming in at the south now. So the only change here was related to the ADA parking. So we did want to maintain one spot on the site, but we wanted to have a little bit more of a landscape and reduce the curb cut. So we reduced it to one ADA space. Otherwise the same, there's a secondary exit and entrance from the south, and that ramps up to the rear space. So this is the previous design. So this is the elevation showing what was presented and approved previously. You can see a couple things that that have changed. So this is where the original entry was to the wine shop and the maker space previously. And then this is where the new entry is. So this window basically got switched with this window. And the only other change was that the entryway here that got a little bit shifted a little bit to the north and got slightly wider. We had a little bit more space when we got rid of the additional retail space. So we had a little bit more of an entry in the middle there. The other elements that we've changed, and I'll show you now, are some renders. Oh, this is the elevation of the proposed. And this is the kitchen in the back. So the idea with the kitchen was kind of to build off of the form of the barn. So it's kind of like the same kind of geometry of another fold, but different material. So it's a lighter gray wood and allows the kind of original shape of the barn to still read as like this strong element on the site. And this is really just an outbuilding that's kind of floating within the landscape. That's also allows the chef to kind of be visible and kind of engage with the landscape. Some rendering. So this on the left was the previous entry. So this is between Kitty's on the left here and the barn on the right. So it used to be that you would come up to the platform and then it would continue up to the wine shop. That has been revised so that the platform between the two buildings provides access to Kitty's and also to the rear yard. So as you come out of the Hudson train station, is kind of your view, you get pulled into this rear landscape garden, which is part of Kitty's. And the wine shop has a separate entrance now, which is off of the front, towards the front street. For ADA access, so we're integrating a ramp into the landscape to give you the ADA access, but also kind of feel part of the overall garden. This is another kind of view looking a little bit towards the north now of that same kind of entryway. This is the entry to the main event space. So previously we had a platform lift for ADA access. So we're also on this going to integrate a ramp access. We also changed just a material change that used to be a cedar wood. We're changing that to a concrete. We had some concerns about just slipperiness of the cedar if it got wet. So that was the other change that occurred. This is the ADA spot. So I don't think we had renders of this previously, but this is just to show you the spot that's at the end of the south end of the site. Nothing has really changed here except this one light fixture at the entryway. We used to have more of a decorative fixture, and now this is just kind of to light the platform there. Otherwise, the materials are the same as previous. And I think that's it. I guess we're going to open for any questions or.
So you don't have a rendering of the rear side with the new kitchen bump out?
Just the elevation.
Yeah. Okay. So can you remind me? I should know this as interim chair. You've already gone to HPC.
Yes, we went there last week to represent this again. So they approved it. They wanted to come back again just because the entryway at that point, we had integrated the renderings for this ramp. So we wanted to show them. They said they would like to see those renderings. So that's what are added to this presentation.
And we're the lead agency on this review?
Yes. So this is more the site plan. So any change to the actual facade of the building is what Landmarks would be doing.
Okay, board, do you have any questions for the applicant? Well, I think we have an important decision to make regarding this application. We've already reviewed it, and when we did that, we had a thorough review process. I think the critical thing for the board to decide this evening is whether the changes that you're seeing this evening require us to set public hearings so that the public has a chance to see the changes and weigh in on the changes, or given that we've already completed our review process previously for a project that is substantially similar to this one, can we waive the public hearing and proceed to a resolution to approve?
You know what, Larry?
Yeah. Teresa, you're muted.
Oh, when they came before, they did not have a kitchen, or it wasn't in that spot. I don't remember.
We had a kitchen, but
it was inside the envelope of the pole barn and was not built as in the screen right now. You can see the lean-to style gray piece.
Yes,
that's for the kitchen. The kitchen used to be housed entirely inside the red box.
Right.
So what's new is that the gray box is sort of attached to the red one, and yeah, there's an addition to the project now.
So you bumped the kitchen out for the purpose. Why did the kitchen have to move?
We needed additional space for the cooking of. Sorry, I'm jumping to the plan, but the original kitchen was this footprint, and we needed additional space for the hood, just for cooking equipment required a larger hood. So, and also if it was within the building, that would mean more mechanical space on top of the barn. So just to simplify and consolidate all that cooking equipment, we thought it was a better solution to kind of have this element that's floating and it doesn't affect the roof of the barn.
Ted, can you show us the overall plan so people can get a sense of the size of that addition relative to the size of the barn? Yeah, that there. So show us there, point out there where that.
So this envelope here, I can sketch over it. This piece is the kitchen addition. And we purposely kind of created this kind of indent so it feels like an element that's more floating within the landscape rather than like an actual piece of the barn that's extending. So we want to keep the character of the original envelope and footprint of the barn.
So the kitchen is going to serve the purpose of the recreation room or the event room? Or is it
Yeah,
gonna
part of
serve
yeah. So when they have events, they can cook for the, receptions.
Would that include, because you also have outside space, so is the kitchen going to be used to serve food for the outside space also?
Only for, so the Kitty's has its own outdoor space. This is only for the event space. So it'd be the same, people, but they would be, for the event on the south part of the site.
Wow, okay, so the kitchen was bumped up because you needed taller space, all right.
Yeah.
Also, it allows the historic profile of the building to not be cluttered, if I may advocate for the applicant. It allows the volume to stay pure because you don't have a lot of mechanical room on top. Also, frankly, from a fire safety point, I kind of like the idea that the dangerous hot things are external to the wood structure of the old building.
But that building is not there, is it? Didn't they knock it down?
Yes, we're rebuilding it because we had to do a foundation. So
Right, you're building a whole new building. That building doesn't exist.
No, they're bringing the building back.
Oh, they're gonna bring it back? Oh.
Yes, it's being restored.
Mm.
So now is the entire kitchen, I mean, I think that the new kitchen idea is good. The entire kitchen is there, or it's there and part of it's where it was?
Yeah, part of it's still where it was. So more of the prep space, like the dishwashing and a cooler, is in the space of the barn itself. And then the cooking equipment that requires exhaust and so forth, it's in the other.
I see. Sounds good.
I think, I really think the issue for us tonight is are there questions we have for the applicant? Do we need more information on the project? That's yes or no. And then do we feel that the scope of changes here rises to the level of difference that we need to schedule a public hearing for this? We are allowed to waive the public hearing should the board so desire to do so.
As the person that's always insisting on a public hearing, I have to say that I do not think this rises to the level of needing another public hearing. This has already been approved. It's already had a public hearing. And I don't think that the changes, are going to make a difference.
I agree.
I agree too.
Jane?
Agreed.
Teresa?
I agree.
All right, so essentially, maybe we should actually have a motion to waive the public hearing.
I moved with the public hearing.
I'll second.
I get my piece of paper out. Give me 1 second. I got a piece of paper for this. Okay. Who did that?
I did, Laura.
Okay,
And I
thank
think John, I seconded it.
Okay, thank you. Okay, and all in favor was unanimous. Yeah.
Yes.
Okay, thank you. Okay, in that case, then I have a resolution to adopt. Why don't, Ted, you stop your screen share and let me drive. Okay, I think I queued it up here. I have. And then I can hit the. Oh, I have two open. Let's see which one is which. I chose poorly.
You did.
Okay, let's try that. Maybe let me close that thing so I don't do that again. Not enough characters on the Zoom screen for. Okay. Oh, for God's sakes.
That's really a long resolution.
Third time's a charm. Okay. Let's get into it. City Planning Board dated November 9th, 2021, resolution for site plan approval for South Front Street Holdings LLC for site plan approval at 60 South Front Street. Whereas the applicant South Front Street Holdings LLC has applied to the HPB for a proposed change to their existing site plan approval dated July 14, 2021. The property is located at 60 South Front Street in the RSC Residential Special Commercial Zoning District. And whereas the HPB has determined to waive the public hearing on the site plan application, and whereas the proposed application is a type 2 action under seeker and no further action is required, and whereas the HPB has reviewed the criteria for site plan approval set forth in 325-35, and now therefore be it resolved that the HPB hereby grants site plan approval for the lot line adjustment. Damn it. Excuse me, let me do that again. Now therefore be it resolved that the HPB hereby grants site plan approval for the site plan as presented on the survey prepared by Kane Architecture and Urban Design. Prepared by Kane Architecture and Urban Design dated October 25, 2021, and finds that the project satisfies the site plan approval criteria set forth in section 325-35H of the zoning code. Do I have a motion?
So moved.
That I know is JC.
It is.
And seconded?
Jane.
Gene. Okay, all in favor?
Aye.
Aye.
Opposed? Okay, we are unanimous. We have approval. Stop or share. Save my changes. What was it? Okay, board, we are moving. We may not have to break our record this evening. Laura, did you have something to say? You're muted.
No, I was just saying goodbye to the applicant.
Oh yeah, goodbye, Ben. And
Bye. Thank you, everybody. Thanks for the opportunity. Okay.
Okay, our other item of new business is 554, 556 Union Street and 555 Cherry Alley. Site plan application from the owner. The applicant has applied to divide 55 Cherry Alley from 554, 556 Union Street. 555 Cherry Alley is an existing non-conforming lot that currently has a garage accessory structure on it. The 554, 556 Union Street lot is currently vacant land. As part of section 325-35.1 of the City of Hudson zoning code, this is a subdivision and needs site plan approval. Do we have the applicant with us still and yet? Oh, I see Mark is there. Mark, will you be presenting? Oh, there you go.
Could you make that kind of a little larger?
Mark, you're muted.
Would you say,
Hey,
Laura?
Laura. Sorry, this is a site plan that's drawn up by Matt Bowe to do the subdivision of this piece of property. I mean, a year and a half ago, I combined these for many, many years. I've owned this property for more than 20 years. These three pieces of property were separate. I combined them to sort of simplify my tax situation with the town and county about a year and a half ago. Now I'm asking to divide off the part that is a garage because I have someone interested in buying it. The person who bought my 555 Warren Street, the old town fair, my gallery that I'd owned for many years. I had agreed to sell this garage that was originally with that building that the Coeeks owned to the owner, but I have to do the subdivision, and that's what this application is about.
Okay. So why don't you see where the
Well, can you see the pointer now here on the little garage is this little space here. It's like 16 by 16. The lot itself is 25 by 40.
We can't.
Is that better? Matt, can you make it so a little bit larger so they can see it? So just to refresh you, originally this piece of property ran from Cherry Alley to Union Street, and there were 3 pieces of property listed on the tax map. This 25 by 40 foot piece has a little garage on it, and I want to subdivide that from the other property, which is on Union Street. So that I'll be able to sell that to the buyer of my 555 Warren Street. But essentially, it's just dividing it up back to the way it was for the last 50 years. I just happened to do it last year just to simplify things, not realizing that I might at some point want to sell it.
Hey, Paul. Questions?
Larry, you're echoing.
Happening in loud. We're here. I'll sell. No. Mark? Thank you. Okay, board, do you have any comments or questions for the now muted Mark?
Sorry, now I'm back. Sorry, I was just about to run out of battery.
Yeah. Mark, is that it's so loud that we are getting an echo from you. So if you can adjust that, that would be great.
Maybe that's better now.
We shall. No.
Sorry. I live in Hillsdale, and we don't always have the best reception here.
Okay. Or do you have the applicant? No question. Mark, please mute yourself. Yeah, thank you. All right. So as previously, we have a couple of options before us. The first matter is, do we wish to waive the public hearing on this? We have the authority to waive that public hearing if we think that this is a straightforward enough manner that does not require a public hearing. The second thing is, if we do waive the public hearing, do we want to proceed to review a resolution for approval, a draft of which we have prepared for our discussion and vote tonight?
Larry, maybe can you just, I see where the little garage is. So is it that little square, or is it the big square?
So, yeah, it's that.
Now it's okay. Oh, it's moving around so much.
So the piece that he wishes to subdivide is the 24-foot wide by 40 feet component at the top of the drawing where the garage is. And that would be sold to the buyer or the new owner of 555 Warren Street. Mark would hang on to the rest of the parcel. And apparently this is how it was originally platted, that the garage belonged to 555 Warren. Mark combined the parcels previously to simplify his own tax purposes, and now wishes to sell the piece back. So he has to subdivide again, re-subdivide basically.
Got it.
So it used to be 3 parcels, right? Parcel 2 used to be a 554 and 556. Those were combined and are staying combined. And the piece on the alley, 555 Cherry, that's the piece that's going to get chunked away and sold to 555 Warren.
Correct.
the piece on the Cherry, is that a parcel or building, or is it just a lot?
There's an existing garage.
It's a sweet little building. It's like,
Where is this? Is this near the Gray House? Next to the Gray House on the corner of Union and Fifth?
Sixth.
It's right next door to the VFW.
Yes.
Okay. Thank you. Wait a minute. Oh, it is? Can I mention who house this was? No?
It was never a house. It was always just a storage garage that was used by the people who owned 555 Warren Street, which was the town fair. They used it for storage, which I've used it for storage for the last 15 or 20 years. And it actually needs some repair. I'm very happy to find someone else to do the restoration on it. As he mentioned, it's a very sweet building, but it just needs work. And almost verbally, not really contractually, I agreed to sell this piece to the buyer of the 555 Warren Street. So I just wanted to re-subdivide these pieces that I just recently combined.
So the person from 555 Warren has to come across the alley to get in this building.
Yes. Yeah. There's a garage door that faces there's a garage door that faces the alleyway that was always used to put things in. It's actually a little two-story building. There's a second floor. But it was always a garage and it was always used for storage. It doesn't have plumbing, and I put the electricity in it when I bought it in 2004.
And it had been owned previously by 555.
Thank you. Sorry, Matthew, can you say that again, please?
The owner of 555 Cherry Alley was also owned by the owner of 555 Warren Street, John Guinan.
Right. Okay, board, I think that, go back to my question. Do we need more information from the applicant? Do we believe this rises to the level of a public hearing? And if the answers to those are no, do you want to proceed with a resolution to adopt?
I think it looks pretty straightforward, actually.
Well, personally, I can't vision the building. I'm trying to figure out what building this is.
Matthew, do you have a handy picture of the?
What am I approving?
You're approving a site plan adjustment where the owner
he wants to sell off a piece of his property.
Yeah. Yep. Be a separate parcel. He combined them, and now he's changed his mind and wants to shed the piece that he combined with the previous one.
I'm sorry to interject, but you can pull this up on Google Maps.
What'd you say?
You can pull this up on Google Maps.
I don't have the.
Matthew, did you hear my question previously? Do you have a picture of the property now?
I was trying to do what someone had just suggested, is to find this on Google Maps, but it's just west of 6th Street, South 6th Street, directly behind what used to be the town fair.
Does everybody else on the board know what this building is? If I'm the only one, then I just don't know where it is.
If someone just pulls up 555 Cherry Alley in Hudson on Google Maps, you'll pull it right up.
Google Maps? Is late, everybody.
Mark, can you stop? Matthew, can you stop your screen share?
Google Maps.
All right.
Then Google Maps.
Hey.
You gotta get that.
Let me get rid of my PDF search from before today.
There it is. That's it.
There's the right. The big. Oops. You gotta get Mark. Look, it's not great, this way of looking at it, but you can kind of get a sense. So it's this fella right here.
It's the one with the ivy on it and the red pinkish sort of garage door.
Yeah, it's brick.
Okay, board. Do we need more information from the applicant? If we do not, are we prepared to waive the public hearing? And if we are prepared to waive the public hearing, do we wish to proceed to a resolution to adopt?
I'm prepared to waive the public hearing and move ahead.
I am too. It used to be, you know, with the Warren Street building, and I don't see a reason for a public hearing on it.
Okay, all in favor of waiving the public hearing?
Aye.
All opposed? Okay. Unanimous. Okay, now I have yet again my.
Wait a minute, I oppose.
Oh, sorry, all opposed.
Me.
Okay.
Why?
I just want I want more time to think about it. At least go to the building and see what it looks like. I don't know.
Okay.
I mean, I didn't get a chance to go see this. I apologize, but I didn't.
I understand, but your colleagues have waived the public hearing, so.
I understand. I just wanted to.
No, I hear you. I understand also. All right, let me see if I have this open. Okay. Let me stop the share that I'm in now. And let me start a share. Okay. Are we looking at the resolution? Okay. Resolution for site plan approval for Mark McDonald for a lot line adjustment at 554556 Union Street and 555 Cherry Alley. Whereas the applicant Mark McDonald has applied to the Hudson Planning Board HPB for site plan approval for a lot line adjustment to divide 555 Cherry Alley from 556 Union Street, tax lots 110-53. No, geesh, I am tired. 110.53-3-60, 110.53-3-61, 110.53-3-62. The property is located in the CC Central Commercial Zoning District, and whereas Section 325-35.1 B2 of the City of Hudson Code provides for the HPB to classify the subdivision as either minor or major. Pursuant to Section 325-42, minor subdivisions are any that create not more than 2 lots, and therefore this is a minor subdivision and only requires site plan approval. And whereas pursuant to Section 325-35 H3A, the HPP has determined to waive the public hearing on the site plan application. And whereas the application for a lot line adjustment is a type 2 action under seeker and no further action is required. And whereas the HPB has reviewed the criteria for site plan approval set forth in 325-35, and now therefore be it resolved that the HPB hereby grants site plan approval for the lot line adjustment as presented on the survey prepared this time by Matthew J. Bowe, PLS,
Yes.
dated October 20th, 2021, and finds that the project satisfies the site plan approval criteria set forth in section 325-35H of the zoning code. Do I have a motion?
So moved.
CW, second.
I'll second.
All in favor?
Aye.
All opposed?
Me.
Nay.
Yay.
Okay. All right, so we are approved. Mark, congratulations. Matthew and Mark, thank you for your forbearance. I appreciate your capacity to stick with it.
Thank
And
you.
I think our chair. I think that Mark, you got to mute. I think that our chair will be in contact with you shortly to do the necessary paperwork. Thank you.
Thank you.
Thank you. Good night. Okay, board, we have one more item of new business, and we can handle this a couple of different ways. We can defer our discussion to a later date. Steve thinks that if we'd like, we can actually add this without too much burden to the special session. Otherwise, we can plow forward and address it. But essentially, the Common Council has asked the planning board to weigh in on a proposal to allow for dining establishments in the R4 residential district. As you probably know, in Hudson, there are lots of sites that were originally built as corner stores or taverns. Those things are now illegal under our current zoning. And there is at least one property owner who would like to convert his property back into the tavern that it used to be. That's Basel. If you aren't familiar with the parcel in question that generated this conversation, it's on North 3rd Street, just behind the mansard roof building that we approved a switch of from 5 units to 8 or 8 to 5. I can't remember.
Oh, yeah.
Cut fire, right? Just across the alley from the parking lot of that mansard roof building is Basel's building. And it used to be a little corner tavern, and it's been altered. So I sent you all today a PDF from the Common Council. I don't know if you had a chance to review that. I can bring that up for you if you want to have it on screen. We can canvass each other and open a discussion now, or we can defer this discussion to our next meeting. Jeff Baker advises us that if we do undertake the discussion tonight, the meeting minutes will suffice as our recommendation to the Common Council.
Okay.
So how do you want to proceed?
Is this the, was this initiated by the person that wants to make it a restaurant, I think?
Yeah.
I forgot.
It's Basel.
And it used to be what was it? It was a bar, right?
Yeah, it was a corner tavern, I think.
Christie's or Joe's or.
Right.
But the issue is, I think the issue, so if we're going to discuss it, I think the issue is that these things used to be scattered all around town, right? And when we established a more uniform zoning code, a largely, frankly, suburban zoning code, we outlawed these things from persisting in areas off of Warren Street. And so the question is, do we, as a planning board, think that change that was made whenever it was made is the appropriate one, or is it now time for us to re-examine that zoning and allow for neighborhood establishments back into places off of Warren Street? And it's not 1924 anymore when these were built. We have parking, noise, lighting issues around these things. It would be interesting for me to hear what the board has to say about this proposal. And I can.
This would be changing the zoning for the whole city?
No, it's in the R4 district. Which let me bring up the memo.
Well, can I ask, what are we doing with the other places? Like Gavin is going to have stores on Columbia, and is it Columbia or is it State?
Alvin's going to have stores on North 7th, right?
In State or Columbia? Which is it? State. And State. North 7th and State. No stores were ever there.
We looked at the brewery recently that's going to be on Cherry Alley. Westerland is going in next door. I mean, there's a kind of unpacking of Warren Street that's going on.
That's true already.
Is that a thing that should be, promoted and accelerated through this kind of action, or do we think as a board that we don't like it? The Common Council simply asked us for our opinion on the matter, and let me just do a screen share. So this is the letter that we got, right? So it's a proposed local law amending the zoning code to allow eating and drinking establishments in the R4 zoning district, see attached. And let's just go through the other pages. There's a couple pages here. So this is the actual wording of the local law. So it wouldn't just be eating and drinking, apparently, right? So adding the following subsection. With respect to any building or portion thereof, the use of which is currently a non-conforming use or was a non-conforming use and did not subsequently become a dwelling unit, allowing retail stores and banks, personal service stores such as, but not limited to, barbershops, beauty parlors, and tailors, eating and drinking establishments, service establishments furnishing services other than a personal nature, including convenience stores. And if I were really on top of things, I could bring up the City of Hudson zoning map.
Yeah. I took a look at it today. I saw where it had pink. The pink was R4. I'm totally confused as to why all of this for one applicant. Is this the first time that someone wants to open up a store in an R4 district?
For God's sakes. Okay, I don't know that this is current because I didn't actually get this from the city's website. I got it from posting on Carol's blog. But let me, there's a way, I know there's a way to.
I think we should use the city website.
Well, then, do you want to find it and share it? Because
I wish I could, but I know it's there. I saw it today when I saw this application. If I wish I knew how to share my screen and search for things, but I need some more explanation on this. So what do we have here? A person, the city wants to change. Oh, there it is. No. Oh, is that the same?
This is current, but I don't know. So you can see the R4 is the pink, right? There's a little piece of R4 over here, which is very curious. So essentially, what we'd be looking at would be things like Talbot Narding moving, right? That there would be more things in this zone here and this zone here that are, I would imagine, although given the laws of good intentions, would be neighborhood oriented.
I'll comment in that I'm a neighbor of Talbot and Arding. I think it's a great thing. I'm very much in favor of, as you point out, Larry, the zoning is very much based on sort of suburban thinking and separating uses in a way that most urban areas didn't naturally evolve. And I think it's sort of, quite frankly, artificial imposition of rules that just didn't exist in cities where bars were intermixed with housing or intermixed with other businesses. So I greatly appreciate the notion that we can move away from that sort of artificial separation. And I like the idea of small businesses being intermixed in residential neighborhoods.
Better said. I didn't understand you until you said that.
So
back in the 50s and early 60s, there was a Utica Club sign at the end of Warren Street, at the upper end of Warren Street, that said there are 54 bars in Hudson, New York, and Utica Club is sold in all of them. So Hudson does have somewhat a history of having little enclaves around the city. I just don't want to see it become a wild, wild west where, somebody can't pay rent on Warren Street. They wind up moving into a neighborhood and it continues, and then there goes the neighborhood. That would be my biggest concern. Excuse me.
I appreciate that, John. Could you just blow that map up a little bit more? Just like make it bigger?
Can you tell what streets are we talking about for the R4?
Sure. Let me see if I can pan easily
Yeah.
here. No, it's hard to pan. Hold on 1 second.
Yeah, what streets are we talking about?
Well, basically, there's a weird outlier chunk here, which makes me quite nervous about this proposal, actually. But let's just set that aside. The main bulk of the R4, assuming that this map is correct, is the backside of Front Street up to 3rd Street, flanking Warren Street. Now there is this
First to second, from second to third, what?
Yeah, front to 3rd, and then the whole thing, cross all the way up to Mill Street. The whole width of town.
And then
Oh, and a little chunk up here.
Where is that? Harry Howard.
This side up to 4th Street. So just to orient you, this is the former elementary school here. The former Alms House is here. The elections building is here.
so it says in the legend on the side, it says multiple 3-story. I can't see it now. What does that mean? R4, it says three-story multiple residence. What does that mean?
That means that it's zoned not as a strictly single family thing, but that multiple is 3 or more. So you could have a 3-unit building and a 3-story building.
I see.
So in the R4 district, there are no retails. Well, okay, so people have to walk a distance to go get butter, milk, bread.
Well, it's complicated, right? So I can tell you this because I live right there where the cursor is. I call it a bodega, although it's run by a Bangladeshi family. There's a bodega here, there's a bodega there. I mean, there are businesses mixed in here. Basil's location is here at the Rope Alley meets 3rd Street.
So you're saying their business is already there?
I bet you they were open before the zoning change and have never ceased operation.
I didn't hear that.
You're muted.
Teresa?
Yes. I didn't understand because you were going in and out. So there are businesses in the R4 district already.
Yes, and I would imagine that they're there, that they were there before the zoning change and have never closed. But places that were there and closed have not been able to reopen in those places because the zoning no longer conforms.
Well, I've been here since 93.
Yeah, but I think the zoning happened in the 60s or 70s.
Was those bodegas there since you've been there, Laura?
Well, I'm on Warren Street, honey, so it's different. Everything is, I can walk up my door to anything.
Yeah, I think that 3rd Street, the bodega's been there for a while when I first came here. So
The one on the corner of 2nd's been here since I can remember. There's one down the street, but again, I'm on Warren Street.
I mean, the one on the corner of 3rd and Columbia has been there. Used to be called Tony's, right, John?
Yeah, it's been there for a long time.
How about the one in the block? Because they're, yeah.
In which block? On Columbia?
It's on 3rd Street going from Columbia to State. There's another bodega in
Yeah,
the.
there's two of them.
There's
Yeah.
one on the corner of State and 3rd.
Right, that one used to be called Tony's. How about the other?
No,
one?
Tony's was Moranti's at the corner of Columbia.
Right, so how about the other one, right?
There's one on the corner of
There forever.
There's one on the corner of State and 3rd, and there's one on the corner of
Columbia and 3rd.
Columbia and 3rd.
One on the corner of Columbia and 3rd has been there.
Yeah, I think we imagine they've both been there because they're probably grandfather status now.
They are.
So I think, the question before us is, do we want to advise the common council? If so, what do we think about the introduction of what seems to be neighborhood-oriented shops, taverns, restaurants in the pink area on the screen? Like, do we want that? Do we like that? What are the downsides? I mean, before the 1920s, it was not so imperative to have zoning because the scale of capitalism did not thrust noxious uses on top of other people, but it was possible to cohabitate. But, in an advanced consumerist economy right now, you could have an extraordinarily popular venue suddenly on what had been a very quiet residential street. On the other hand, I think it's fantastic to think about unpacking Warren Street and spreading jobs and opportunities and businesses, into the neighborhoods where they might serve the needs of the people who actually live there.
Does this mean right now, for example, if somebody bought a house in the R4 district and they wanted to have a B&B, any type of, or an inn, whatever, they wanted to convert the house to transient living, they can't do that now?
That's not the issue before us. That would have to be, that would have to depend upon what was allowed in the R4 district. This is particularly concerned with retail storefronts in the neighborhood. So not hotel.
Only retail storefronts.
Yeah, retail storefronts.
Okay.
The examples that they gave, it was nothing like a hotel at all, right? It was retail stores and banks, personal service stores such as, but not limited to, barbershops, beauty parlors and tailors, eating and drinking places, service establishments featuring services other than of a personal nature, including convenience stores.
I mean, my only concern would be that what are now, places for people to live would become something that's not for people, it takes away some housing issues, but otherwise it seems like a good idea.
Well, to me, it seems like a way of fostering a level of entrepreneurism and economic vitality that is outside of the rarefied confines of Warren Street. I mean, I walk down Warren Street and it's so rare for me to see people who live on my block on Warren Street, right? There's the town is getting really prettified on Warren Street and frankly rather exclusive. And it seems to me that allowing small property owners to develop small local businesses might be a wonderful way to revitalize neighborhoods.
I totally agree with you. Plus it gives the people in these R4 neighborhoods that don't have a restaurant nearby or a store nearby, it gives them a chance to access these particular things without getting in their car driving or walking a long distance.
I'm sure that I'm sure that they have gone through some kind of a process wherein the people that live in the R4 district have been able to voice their opinion. I mean, I think that they're the ones that should also be being.
I think we're in that process right now, right? That this is one step in that process.
I see.
Gene, you haven't said anything. Do you want to weigh in on this one?
Well, I don't know. I've got mixed feelings about it. You know, the residential areas, the establishment you're talking about it was there years ago, what, changed hands 2 or 3 different times. But I don't know. I can't give you an answer right now.
Got it.
Can you tell us what your reservation is, Gene? Because you've lived here your whole life.
It's just that it's all residential, and you start bringing in these businesses of different sorts, it could create problems for the neighborhood. You know, people don't want it in my backyard, so to speak.
Yeah.
You know, it's been quiet there for the last 30 years. Now, if you start bringing in different businesses of sorts, it's not going to be a quiet neighborhood anymore, and I don't want to be here anymore. Something like that.
Yeah. Especially if it happens in the alleys. I can imagine, like, you know, some Brooklyn hipster creates a speakeasy on Partition Street, and the next thing you know, you've got a little velvet rope and a guy back there, you know. Yeah.
You know, another point of, and I always go back to this, is, you know, parking. With Talbot opening up on the corner of 2nd Street, with the fact that, you know, Tony and Melissa have their production place in the old Allen Street School.
Right.
Allen Street is jammed with cars, you know, during the day. Nighttime, not so bad. But, you know, you add things to that, especially on a street like Allen. And, you know, I just.
No, it's, I hear you. I mean, I went to Rolling Grocery the other day, and I was like, oh, you know, I mean, I walked there, but I can imagine that folks going to Talbot and Narding and Rolling Grocery are now suddenly realizing that 2nd Street's a lot harder to park on than it used to be.
2nd and Allen both, yeah.
I like the idea that, of course, one would hope that the neighborhood businesses would be neighborhood-y and folks would walk there.
That's not Hudson today, though, Clark. I don't think.
Well, again, it depends. Like, I think a lot of folks go into Talbot and Narding. I mean, I live right near there, half block away.
Yep.
And I'm parking in the alley, so I don't see a huge influx of cars.
Okay, look,
I
my
just want to
intent
say one
is,
more thing, and that's we don't know why back when zoning was changed to what it is now, we don't know why that was done specifically. So I guess I just don't think that should be a consideration. In other words, you guys were talking about, it's now we're now here, this place as a city, and we're not where we were in 40 years ago, 50 years ago when they did this zoning, but we don't know why they did this zoning. It could be, you know what I mean, guys? I don't think that because it was then and now's now, that there might not have been a good reason why the zoning was changed to what it is.
Yeah, I hear that. Okay, board, it's we have some administrative matters. I think that we've talked enough that the common council can gauge what the interest as we see them are. We do have some administrative matters. Let me stop my screen share, which I think did. I gotta look at the agenda. Where is my agenda? Okay, so our first item is to review and approve bills. I need to bring those up to my screen, don't I?
Yes, you do.
Okay, let me do that. I have to tell you though that I have to use the bathroom. So
you cannot go.
I have to. Let's do the one first that you don't have that. Let's do this one first and I'll be right back.
Teresa can talk us through them, right, while you're gone?
Yeah. She doesn't have them all. Let me see if I can open more than one thing at once. on this? No, I can't.
I'm sorry, talk us
Start
through-
with this one. I'll be right back. I'll be right back. Teresa, go ahead and start us. You can see it, right?
Teresa, we can't hear you.
Oh, 3 bills that are being shown here now are what I received today. So they'll be added to the proper invoice of the proper escrow account. I just didn't want them not to be paid or approved today. I can't move the screen because he shared.
Yeah, okay.
Let me see if I can share. I'm gonna try this myself.
Okay, so we can see it. We can see it.
Oh.
I mean, I read it, but
No, yeah, these, and I tried to send them to everybody to take a look at so that we would be able to approve them. Their invoices, 3 invoices coming from the same company going to the different, I think this is the same company that Victoria works for.
I think this is all Victoria. I read it early, right when you sent it, but I was rushing because it was.
They're not that big. They're very small. They can be added to the other invoices, and it doesn't put any of the escrow accounts in jeopardy at this time or at this meeting.
Okay, it's good to me.
You know, it's important that we kind of review the bills and pay as many bills as we can during the meeting so we can keep up to date. You know, one thing Clark was right about, it is an issue, and it seems like it's on us to keep them up to date, to be paid and to get to Tracy as fast as possible.
Okay, so should we take a vote on this, or do we just want to wait and do all of them at the same time?
It's up to everybody. Where's Larry? Oh, he didn't come back. Any questions?
Looks reasonable to me.
It's okay to me.
Thank you.
Okay, where are we, guys? Can you fill me in?
This looks good. Now we need to see the other one.
Okay.
These are the invoices that those bills that you just saw or reviewed, they will be placed on the proper invoice for the proper escrow account. And we approve them tonight, and then I'll have them ready for Tracy tomorrow morning.
Okay, so help me out. Where are we on these? What do I have to do?
We have to approve them. See,
these are
these are additional invoices to go on the proper invoice sheet for the escrow account. I received these today. I didn't see them until just before I sent them to everyone. But I did not want to wait until next month. You know, it's important that we get these bills paid, get them in, approved, and paid.
So on this page, this is all there is the Alta one?
No, there's another bill. Okay. This is the invoice for the escrow account. Every escrow account goes on an invoice like this, a separate invoice. And on that invoice for the escrow accountee, you have to put down the bill that's coming out of this account. So there will be one more bill coming from Victoria's firm that will go to this account and the other 2 accounts. We've got 3 bills from Victoria's firm, and each one of them will go into one of these escrow accounts to be paid. So each one of these will have 2 bills. I just have to pull them down from where I saved them, print them up differently save them again and send them to Tracy, but we have to, I'm asking that they be approved tonight.
Okay, so basically what I understand is that we have an Alta bill for $859.50, which is for the Elephant Project. We have a
Wait a minute, we have another bill.
from Barton and La Judas for $24.79 on ACS. And we have a bill from Verity on Pocketbook for $2,537.50.
Right, and we have another bill.
And then this bill is the one that has not yet been reformatted in the way that we saw previously, correct?
Yeah, it's 3 of them, yes. They're not formatted the way you see, but they will be formatted tonight when we're
And
finished.
they're all for Victoria's firm.
Right, it's 3.
Understood. Now, Teresa, is there any one of these that are bumping up against the balance in the escrow account? Do you?
No, at this time, none of the balances, if, once these bills are paid, none of the balances will be, will be in jeopardy, but Gavin's balance will be $1,115, but aren't we finished with him in a way?
Yes.
Okay.
And
So,
a stipulation on their approval is that they'll pay all escrow fees. So,
yeah.
so their approval.
So none of them will be in jeopardy. If they were, I would have, told you that we're gonna need a resolution to.
All in favor of approving the bills as presented tonight?
Aye.
All opposed? Okay, Teresa, you may move forward. We should have actually made a motion to vote. Can we have that?
A motion
So
to
moved.
approve the bills. Second.
Okay, we are done. All right, now we need committee reports, HCDPA and IDA. I believe that HCDPA is Stephen Stimes' committee, which he cannot weigh in on tonight. Do you have any IDA news, John?
Not much. The only things to report, we had some conversation about one of our consultants, and we also wound up getting the payment in lieu of taxes proposal from the Pocketbook Factory.
Okay. Great. Oh, I'm supposed to ask you about your training hours. Who raise your hand if you still have training that needs to be achieved during this year?
How many hours? How many hours are we supposed to do?
4. But I'm not there, so I may not be the best person to ask.
I'm a half hour short.
I think I'm a half hour with you, John, because I took that same training that you had passed on.
Right.
Who keeps the running tally of our hours? I didn't do any this year, but I had some carryover. So who's the record keeper here?
I believe that the record keeper is the chair, and I believe that Betsy Graham-Cow probably did not forward her spreadsheet of hours to Steve, although she may have.
You get that.
That's probably the responsibility of the planning board member, Clark.
Possible, yeah. I'm obviously admitting to my failure here.
Well, I have 0 hours so far this year, so I better get moving. All right, is there anything else, folks, that we need to go over this evening?
I was just going to bring up a brief thing. I know we're only 5 hours in here, so we're doing great. The issue of sort of lack of support to the planning board. I mean, you and I Larry, talked about this. We have a lawyer, but they're on retainer. We don't have a secretary. So I think in addition to the burden of having 2 meetings a month now, oftentimes going to 5 hours like we are tonight, the support that we're receiving is inadequate in my mind. And I know it's usually the chair that takes on the biggest burden, but I'm just sort of speaking up, I guess, on behalf of the chair and the interim chair's excellent work. And maybe there's something we can do jointly to appeal that we have the services we need.
I think it's imperative that we communicate to the mayor's office and the common council we have a huge resource issue, right? I mean, I spent 4+ hours today drafting resolutions and going through the materials that we could meet tonight. And that ought to be in one of our lawyers' offices, and they present those things to us and we proceed properly. We have no secretary. We only have a lawyer for escrow accounts. That might get even worse if whatever the budget scenario is, and we have no standing counsel. And we're volunteers. I don't see how the city of Hudson is going to get citizens interested in public service if this is the burden that we place on folks engaged in public service. Because I am about 1 week away from wanting to get off this board. I can't maintain my work, and I'm a primary caregiver now to a woman with Alzheimer's, and I can't do it. It's like, and it's not reasonable, and we have to do it in a context in which we're under threat of legal action. We're being foiled for the second time in a matter of months. It's the volume of projects. They're really big projects. We're looking at things like Galvin and the Pocketbook Factory and Verizon and ACS. These are really big projects that we have to review, and we don't have any sort of administrative or institutional support to carry us forward. And I don't know. I mean, I talked to Steve today. He's where I am. I mean, I don't know that we're going to have Steve next year if this continues. And it's maybe we need to write a joint letter about to the mayor's office requesting that they reevaluate the level of support the planning board gets from the city. I mean, we're looking at multi-million-dollar developments. There must be associated fees with those projects. And why am I taking up my workday to develop resolutions for private developers who are making money in town? It doesn't make, I mean, the model, this is citizen democracy. And if you make it so difficult for the citizens to participate, what's going to happen?
I think it's combined with the fact that, when I started, I guess almost 5 years ago now, there was once a month and it was 3 hours, 3.5 hours. And now we're, in addition to this additional work, and again, the chairs have taken on largely, but we're now, with preparation and the meetings is, I don't know, 15 hours a month, 20 hours a month, maybe more, probably a lot more actually.
Between Friday and now, Saturday morning and now, I'm easily at 18 or 20 hours. And 2 of those were a weekend, right? Like it's the burden on the planning board is too much. Either the city needs to hire a professional planner so that a lot of these things that we go through don't ever get to here. I mean, or there needs to be 2 planning boards, one for different districts in town. I don't know what the answer is, but the notion that citizen volunteers can carry this burden, it doesn't make any sense. I mean, it really.
I've been on this board the longest, I think. Well, Gene's been on and off, and it doesn't really matter, guys. To not have an attorney for the board is, I think, really bad. And I think now I guess I'm understanding, or I'm not sure that I understand, that there's a possibility that it will continue, that will be, we'll have an attorney by hire. And I guess that means that now all applicants are going to have to pay for, and are going to have escrow accounts. I don't really understand what's going on, but that seems to be the direction. But there won't be a city attorney. So I don't understand that. So for a simple subdivision, it's going to be up to the chair to write the resolution. I don't get it.
No, I mean, we could have finished Basilica 10 or 15 minutes sooner tonight if we had a lawyer who could have figured out how to write a sentence about noise. And you multiply that by the 7 or 8 projects that we review each meeting, and that's an hour and 20 minutes of our inefficiency, right? Because we don't have a lawyer to guide the damn documents, right? Like,
I think that the, look, guys, I'm gone, bless myself and you after this term.
the one thing that disappoints me the most, and I think you're all wonderful people, and it's been my pleasure, to have, a city official in some way making fun of us or, criticizing us for having 5-hour meetings. I mean, we just had a 5-hour meeting. It's not, I don't think that that's, I go to what Larry said, who's going to volunteer when in essence there's all the homework that we do, all the work that we do behind the scenes, added to a foil, which literally took me an 8-hour day, a whole week's worth of, if I combined it together, I did a whole week's worth of work on that foil because I've been there so long. So I really had to go through so many emails. Who's going to do all this and then have a city official in some way criticize us for having 5-hour meetings? We're doing the best we can, and we're doing it without a lawyer, and now we're doing it without a secretary. So I think that that's unfair, and I thought that comment, if indeed it's even true, was uncalled for.
I also think that, and I've talked about this to all the previous chairs, Betsy and Steve, and now of course Larry, about sort of somehow, there's this general notion that our time is unlimited. And yeah, I've brought this up before, but in my experience in New York City, to get on the planning board's docket could be months, if not, could be many months. And so there's this notion in Hudson that our time is limitless. And of course, in New York City or any other municipality, many other municipalities, it's obviously limited resources that make this, make people wait. And there's just no sense that anybody's going to be waiting. Everything that comes on our docket is automatically on our agenda. And there's no sense of the amount of time that we're putting in. And we willingly volunteer, but I think many of us are at the end of our rope in terms of how much we can put in. There's got to be a way to manage the time in these meetings. There's got to be a way to manage our time where we cut it off at 3.5 hours or something. I don't know.
Well, Larry did tonight. If we couldn't come up with something, that was good, Larry. You basically said, okay, we've talked about this for an hour and a half or an hour or whatever it is, and we need to move on. We'll come back to it.
Right, but it still took us 5 hours.
I know, it still took us 5 hours.
And we bumped Colarusso. We had took on Colarusso tonight as well. I mean, it would have been
supposed to have an executive session tonight as well, and we refused that, right? Like,
I know that's what was supposed to happen, and
Right.
that's
Right.
well, I don't know what the answer is, but I think it's a shame if it's that we lose really great board members because of this.
well, let's think about how we proceed. I mean, I think that perhaps we can write a collective letter to the mayor and to the common council and let them know that the current resources dedicated to supporting the planning board are insufficient, and that we risk alienating current board members and frankly the ability to secure future volunteers to serve. And maybe that will have some impact. I don't know. All right, so I think we can adjourn our meeting. It's 11:13. I appreciate and admire all of your dedication and commitment. It's extraordinary. Across the board, I think we're doing what we can. And I will see you next week.
Larry, remember to send Tracy a little note to approve all bills.
I will. I have a whole stack of files that I have to manage. Won't be tonight.
I think that
I
everybody.
have a motion to adjourn.
Yeah.
So move.
Second.
Got it.
All in favor?
Aye.
Aye.
Aye. Okay.
Aye.
Adjourn. Thank you again.
Thanks, Larry. You're doing a good.
Aye,
Thanks
thank
so
you.
much.
Larry.
Good
Bye.
seeing you.